technical issues. Ladies and gentlemen, members of the jury, good afternoon.
Ladies and gentlemen, esteemed guests and colleagues, welcome to the live stream of the 2023 Cantor and Pintaluga Summer Associates Mock
How many times
Trial.
did I say good afternoon?
We're delighted to have you with us this evening. This event is the cornerstone of our Summer Associate program, and it's an opportunity for the students to transform theory into practice through strategic thinking, persuasive presentation, and effective communication. These associates have spent their summer soaking up knowledge, developing their legal skills, and seeing firsthand the practicalities of the legal profession. Now, it's their time to shine. They get to apply some of what they've learned, demonstrating their understanding of legal principles, courtroom decorum, and most importantly for tonight, zealous advocacy. This mock trial is more than just a performance, though. It's a testament to their growth and learning journey throughout their summer tenure with us. And this opportunity teaches students not just the art of argument, but also the power of empathy, ethics, and authenticity, values that Cantor and Pintaluga cherishes and celebrates. So sit back, engage, and enjoy the exciting display of budding legal talent that's about to unfold. Thank you for being with us tonight.
All right, good afternoon again. Members of the jury, if you'll please rise, let me swear you in. You solemnly swear or affirm that you will listen carefully to the testimony and the evidence presented in this case, and then apply the law to the facts as you find them and render your verdict. All right, you all may be seated. All right, we have, again, for the record, case number 13 CV 17-8995, Cameron Carter as personal representative of the estate of Kenneth Carter and Cameron Carter individually versus Colonial Casino and Racetrack, LLC. Will the attorneys representing the plaintiffs in this case, the estate, as well as Ms. Cameron Carter individually, please rise and note your appearances for the record.
Good afternoon, Your Honor. My name is Alexander Tyler, along with my co-counsel, Camilo. We here represent the plaintiff, Cameron Carter, in the action today before the court.
All right, thank you. You may be seated. And representing Colonial Casino and Racetrack, LLC.
Good afternoon, Your Honor. Hashemian and my co-counsel, Ramputh, on behalf of Colonial Casino and Racetrack.
Good afternoon. Are the plaintiffs ready for trial?
Yes, we are, Your Honor, although we have some preliminary matters we'd like to address before, if that's all right.
Can we do so outside of the presence of the jury?
Whatever Your Honor would prefer.
I would prefer.
Okay.
All right, members of the jury, y'all talk and y'all come over here. Cameron.
You want to go? You need me to go? You need to go?
Sorry, Your Honor, more housekeeping matters than anything else. May we assume that all sidebars will be constructive sidebars unless otherwise requested? Yes. May counsel be freely permitted to move about the well?
Absolutely.
May we constructively invoke Federal Rule of Evidence 615, witness sequestration?
Done. Unless there's an objection.
No objections, Your Honor.
All exhibits, they've been pre-marked with letters. Would Your Honor accept counsel introducing evidence as previously marked?
As previously marked, unless there's an objection, are there any new exhibits that haven't previously been marked?
No, Your Honor, no objections and no new exhibits will be presented today.
All right, and after that, plaintiff has no further preliminary matters, and as previously stipulated. I'm fine yelling.
All right, before we had the sidebar, I had asked counsel for the casino to introduce yourselves again for the record. So it's Mr. Aslan and Mr. Ramputh?
It's Mr. Hashemian, Your Honor, and Eric Ramputh.
Okay. And Mr. Tyler and Mr. Mello.
It's Mr. Camilo. Your Honor.
Mello.
But otherwise, yes, Your Honor.
Like the basketball player.
Yes.
Okay, you got it. All right, at this time, members of the jury, you've been selected and sworn. The attorneys are going to give what is called an opening statement. The opening statement is not evidence, and you cannot consider what the lawyers say to be evidence. But I'm going to ask you to listen very carefully, very closely to what they have to say, because it's intended to aid you in understanding what the evidence will show in this case. Would the plaintiff like to present an opening statement?
Yes, Your Honor.
You may proceed.
Thank you. March 24th, 2018. It started out like a regular day at Colonial Racetrack. See, it was a weekend. They were going to put on a race like they normally do. Thousands of people were going to come, watch the race, place bets. It was going to be a good time. But while it started normal, March 24th, 2018 did not end normally at Colonial Racetrack. And it didn't end normally because an entirely preventable accident took the life of Mr. Kenneth Carter. And the evidence will show that Mr. Carter died because an untrained horse, new to the track, Southern Charm, was unexpectedly introduced to the race by the owner, Mr. Fonsetti, who's the defendant in this case. And he introduced him in spite of a history of repeated behavioral problems and safety concerns. And now the circumstances surrounding this evidence, surrounding this incident, they raise questions. Questions about the defendant's decisions. And that's why you all are here today. You're going to look at his choices, at the risks the defendant made other people take, and how he gambled the life of Kenneth Carter on a horse, and he lost. But it was Mr. Carter who lost his life. Now you'll hear a lot about Southern Charm. You'll hear that Southern Charm arrived at Colonial Racetrack only 1 week before the race. Just 1 week. And when he arrived, Southern Charm was inexperienced. Only 2 years old, Southern Charm had never raced before. Southern Charm had never received a single day of training before coming to Colonial. And everybody who worked at Colonial will tell you they weren't expecting him to race. Now, not the head trainer, Blake, not the lead starter, Jamie Wright, and certainly not Kenneth Carter. They weren't expecting him to race that day because he simply wasn't ready. But on that day, you'll see that the defendant, he found himself in a bit of a situation. Because normally, you have 5 horses that race. But when the defendant arrived that day, he heard one of the horses was sick. There were only 4 horses. And you'll hear that situation is what they call a short field. It's short because there's not enough horses. And you'll hear the defendant was concerned about this, because fewer horses means fewer bets. Fewer bets means less money for the defendant. So he was going to do something about it. He got there and he goes and he has a conversation with Jamie Wright. And he goes to Miss Wright, and he says, I'm concerned about this short field. And Jamie Wright will tell you they had this conversation. Now, they don't remember exactly what they spoke about, and that's all right. But we know that they were both concerned with the short field. And after they had that conversation, you'll see that not even an hour later, Southern Charm is added to the list. 4 horses, a conversation, 5 horses. You'll see that today. Now, the defendant, he's the owner of the racetrack. Mr. Carter, he was just an employee. You'll see he was what's called an assistant starter. Simply put, it was his job to get the horses, big 1,000-pound animals, and he was supposed to load them into the starting gate for the race. But you'll see these gates. They're small, they're cramped, they're narrow. Quite honestly, it's difficult to make a horse, a very large animal, want to go into that gate. It takes a lot of expertise to get them inside, and it's a dangerous job. Because if a horse isn't properly gate trained, if they don't consistently enter that gate and they resist, it can be deadly for everybody involved. Now, you're going to see the gate. You're going to learn all about the loading process. You're going to learn all about the training process. But specifically, you're going to learn about the training that Southern Charm underwent. And you're going to hear that from the head trainer of Colonial at the time, Blake Bauer. And he'll tell you, in his short time, remember, only 1 week, they only gave Southern Charm 1 week of training, that after that short time, Southern Charm was simply not ready to race. Because you'll hear in the week leading up, Southern Charm displayed consistent problems with starting. He wouldn't enter the gate. He would dig his hooves in. He would even rear up at times. Simply put, he just never got comfortable with it. And that's all right. He only had a week. But you'll see that racing Southern Charm in that untrained manner violates the defendant's own policies and procedures they had in place that day. Now, Kenny, he works there. He's obviously seen this horse in the week leading up. He's seen all the problems. And so when he gets there and they tell him, you've got to load this horse you didn't think was racing at all, this horse you know is dangerous, that's your job to load that horse now. So naturally, he's concerned. But he can't complain to his boss, so he does the next best thing. He complains to his wife. You know, he takes out his phone, he starts texting her. He says, hey, that horse I was telling you about, the young one, the experienced one, the dangerous one, all of a sudden he's starting now, and I have to do that. Now you'll see those messages, and those messages are powerful because those are the last things he would ever say to his wife. But at the end of the day, it's Kenny's job to load the horse. He can't disagree, you know. It's not his call. So he's going to load the horse. That's his job. He just didn't know that after 15 long years at Colonial Racetrack, Southern Charm would be the final horse he would ever load. Because you're going to hear about Kenneth Carter's final moments. You're going to hear about him from Jamie Wright, as I mentioned, the head starter. Now, Jamie is in charge of getting all the horses ready for a race, and she'll tell you that day she was waiting there. She had one hand on the starting lever, and she was waiting. She was watching Mr. Carter try to load this horse, and she saw every single other horse load correctly, except for Southern Charm. Now she's watching that, and she's watching Kenny struggle. Kenny's trying to get her to move. Of course, Southern Charm doesn't move. Again, he's just digging his hooves in. It won't move. Kenny has to call over another assistant starter. They both try and push him in. They're struggling for minutes, and Miss Wright is watching this. And you'll see that that's against, again, the policies and procedures set forth by the defendant. But finally, after a few minutes, Southern Charm, he loads. He agrees to load. And Jamie Wright's thinking, oh, thank God, let's get this show on the road. So she turns around, ready to start the race. And that's when tragedy happens. Because right when she turns around, right when she doesn't see anything, bam, that's when it happens. Southern Charm, young, inexperienced, got spooked inside the gate. He rears up. He hits Kenneth on the side of his head, right here in between his eye and his ear. This is a 1,000-pound animal. Kenny falls to the ground. He's not moving. Paramedics are called, and they rush him off to the hospital. And while everybody's sitting there, everybody's thinking, wondering, oh my God, I just watched my employee, my friend, get hurt. You know, he's off, his fate's unknown, we don't know what's going to happen to him. The defendant, he tells him, run the race. What are you waiting for? Cancellations are bad for business, you know? So the show goes on. It goes on without Southern Charm, but most importantly, it goes on with Kenny. Because Kenny would never return. He wouldn't return to Colonial. He wouldn't return from the hospital. Because medically speaking, Kenny unfortunately passed away before he even got there. But realistically, you'll see that Kenny's fate was sealed the very moment the defendant decided to start Southern Charm that day. It was over. Now, in this case, the burden of proof is on us. We have to prove by a preponderance of the evidence that the negligence of the defendant directly caused the death of Kenny Carter. And we will meet that burden because the evidence will show that Southern Charm was not ready to race. Southern Charm was not properly trained. And Southern Charm was known to be dangerous. But in spite of all that, the defendant put Southern Charm out there anyways because he didn't want to lose money. He gambled Kenny's life on a horse and he lost. But it was Kenny who lost his life. And that's why at the end of this trial, my co-counsel, Mr. Camilo, he's going to be back in front of you and he's going to ask you to return a verdict. And the verdict he's going to ask you to return is the only verdict that's going to be supported by the facts, it's going to be supported by the law, and most of all, it's going to be supported by your own common sense. And that verdict is that Colonial Racetrack is liable for the death of Kenneth Carter. Thank you.
Did the defense like to present an opening statement?
Yes, Your Honor. Good evening. My name is Eric Ramputh, and along with my esteemed co-counsel, Shaheen Hashemian, we have the distinct honor and privilege of representing the defendant in this matter, Colonial Casino and Racetrack. The owner of Colonial Casino and Racetrack is Mr. Frankie Fonsetti. Frankie is 67 years old, and he's owned Colonial for the past 36 years. Frankie inherited Colonial at the age of 31 after his father tragically passed away in a car accident. You see, Colonial is a family business. It was run by Frankie's father and grandfather before him. And if you do the math, Frankie's owned Colonial for more than half of his life. It's fair to say then that Colonial has been a central pillar, a guiding light of Frankie's life. And that it has provided not only for him, but for his family, and for most importantly, the workers who have worked and continue to work at Colonial Racetrack and Casino. Now, one of those workers who worked at Colonial was named Mr. Kenneth Carter. You've heard plaintiff's counsel speak about Mr. Carter a little bit. Mr. Carter had worked at Colonial for 15 years, almost 15 years, as an assistant starter. He was a valued member of the Colonial team. And Mr. Carter unfortunately passed away on March the 24th, 2018, as a result of a fall from a starting gate head first onto the ground, which were life-changing and life-ending injuries. Now, when a tragedy like this happens, and make no mistake, this is a tragedy, the question that we typically ask ourselves is, why? Why did this happen? How did this happen? Who is responsible? And to get to that question of who is responsible, you first have to understand what a racetrack is and how dangerous horse racing is. Horse racing is an immensely dangerous sport. As plaintiff's counsel said, we're talking about 1,000-pound animals. These are animals that have strength and speed that dwarfs any human being. They're both magnificent, yet dangerous. And in order to be involved in horse racing, you need to have certain levels of protection. You need to have modern rules and procedures for both training and handling horses. And you also have to have safety equipment. Now, when you're training a horse, you need to have those rules and procedures in place. And Colonial Racetrack had these rules and procedures in place. And it's important because if you're on a horse and you're a jockey and you're riding that horse, you've got to wear a helmet, you got to stay on the saddle in the center of it. If you're an assistant starter like Mr. Carter was, you have to wear a helmet and you have to wear a flak jacket. So these are two layers of protection, rules and procedures and safety equipment But Colonial Racetrack had a third layer, and that was an emergency medical team on standby to assist Colonial's patrons and employees in case anything happened. 3 layers of protection. That's what it takes to be involved in a sport like horse racing, but even then, unfortunately, it may not be enough. Now, Mr. Carter's day began on March 24th, 2018, by leading Southern Charm, the horse that's at the center of this controversy, into the starting gate. And Southern Charm did show some hesitancy to enter that starting gate. That's not in doubt at all. And it's not abnormal for a horse to show hesitancy to get into a starting gate. Remember, horses are animals of prey. They're not going to fight. The first time they see a confined space or they see some sort of danger, they're going to try to run. And the starting gate is there to mitigate that, to keep the horses in place and to prepare them for the race. And on that day, Southern Charm did show some hesitancy. And there are rules and procedures that you'll hear about later on how to load a horse into a starting gate when the horse is showing some hesitancy. One thing you can do is put a blanket over the horse's eyes and lead it into the starting gate. Another thing you can do is you can interlock arms behind the horse and gently push it into the starting gate. Unfortunately, that did not happen. It did not work. And as you'll hear through evidence and testimony tonight, Mr. Carter did something a little different. Instead of using those methods and procedures, Mr. Carter actually hit Southern Charm on his nose, not once but multiple times. And there's a reason that that's against the rules. And unfortunately, we all know how this story ends. Mr. Carter falls from the starting gate and he tragically passes away. And that leaves us here tonight. So as you consider this trial, as you consider the evidence and testimony that's presented to you tonight, there's a few things that you need to know. First and foremost, it is undisputed that Colonial Casino and Racetrack had rules and procedures in place for the training and handling of their horses. Evidence and testimony from Mr. Jamie Wright and Mr. Frankie Fonsetti will show that to be the case, and it will show that they conveyed that information to their employees. Second, it is undisputed that there was safety equipment in place and available to employees like Mr. Carter with regard to their jobs, such as the certified racing helmet that was required of him and other starters to wear, and the flak jacket. And third, and most sadly, the evidence and testimony tonight will show that despite it being required under the rules and procedures that were known to Mr. Carter did not wear the helmet and flak jacket that was required of him. So those are the crucial facts that you need to know going into this entire trial. So what then is your job? Well, as the jury, your first job is to be the fact finder of this case. You have to apply the law. You have to evaluate all the facts that are going to be presented before you. It's understandable that you have sympathy for Mrs. Carter and for the situation that Mr. Carter found himself in. This is the loss of innocent human life. It's always going to be a tragic situation. And as tragic as this situation is, you have to remember that you cannot use your sympathy for Mr. Carter and Mrs. Carter and put the law to the side. You have to apply the law. And you're going to look at the standard tonight of whether the evidence shows that we, Colonial Casino and Racetrack, were responsible for Mr. Carter's death. But the evidence will not show that. The evidence will rather show that Mr. Carter consented to the dangers inherent to horse racing, as he was a 15-year member of Colonial Casino and Racetrack, and he was well aware of the dangers of racehorsing. The evidence will show that Mr. Carter was not wearing his racing helmet. He was not wearing his safety equipment. And the evidence will also show that Mr. Carter, sadly, was the party most responsible for his death as a result of not following the rules and procedures and wearing the required safety equipment. It's for that reason, ladies and gentlemen, that at the conclusion of this trial, when you hear all the evidence and testimony presented to you tonight, that I am confident, along with my co-counsel, that you will render a verdict for the defendant, Colonial Casino and Racetrack. Thank you.
Thank you. Plaintiff may call your first witness. All right. Take a 5-minute recess. These people are not going to elect me. keep trying to be good so that they'll bring me back. So yeah. Thank you so much. Okay. All right, you may call your first witness.
Your Honor, I would like to call Cameron Carter to the stand.
Ms. Carter, please approach the witness stand. Remain standing, and I'll swear you in. Please raise your right hand. You swear?
I do.
All right, be seated. Please state your name and then spell your last name for the record.
My name is Cameron Carter, C-A-R-T-E-R.
You may proceed, counsel.
Ms. Carter, can you please introduce yourself to the jury?
Yes, hi, I'm Cameron Carter.
How do you know Kenny?
I was married to Kenny.
I'm sorry for your loss, Ms. Carter. Do y'all have any kids together?
We do. We have Kenny Jr., who's 9.
Named after his dad, I suppose.
Yes.
Now, Ms. Carter, I'm going to get a little bit more into your background. So I'd like to ask you, are you doing anything for work?
Currently, I am an administrative assistant at a tire shop nearby.
For how long?
I've been there a little over a year now.
And what were you doing before that?
I was a stay-at-home mom for 2 years before that.
You were taking care of Kenny Jr.?
Yes.
And before that, were you working anywhere else?
So I was a stay-at-home mom for about 3 years. Before that, I was working at the Colonial Racetrack and Casino.
How long were you working there?
10 years.
While you were working there, what did you do?
So I was a clocker and I was a teller.
And before we get into that, I want to know, why did you stop working there?
Well, I was working there for about 10 years, and unfortunately, there was a flood that happened in the administrative office. They had to run a background check, and from that background check, they found that I lied on my application and fired me.
Can you tell us more about the issue with the application?
Sure. So a long time ago, I was helping at a PTA fundraiser for my older children. So many years ago,
Objection, Your Honor.
Daisy, overruled. You may proceed.
yes, so many years ago, before I started working at Colonial, I was participating in a PTA fundraiser for my older children. I have 2 children who are in their late 20s now, but they were back in middle school and high school back then. And I was working at this fundraiser, and $3,000 went missing. The PTA and the administrator accused me of stealing that money. I didn't. I told them that I didn't. But they pursued and they pressed charges against me and for embezzlement, for stealing money, even though I said that I didn't. The prosecutor was very aggressive, and he said that I would either...
Don't tell us what somebody that's not in the courtroom said. Just what you said and what you did.
Okay, yes, Your Honor.
You might want to throw a question in there.
And when was this happening?
This was happening, gosh, so I applied to Colonial in 2005, so this must have been 2002, 2003.
And Colonial found out about this issue that you were having in the legal system?
Well, no, not exactly. So I ended up pleading guilty as part of a plea deal. I didn't do any jail time, but I have a criminal record. When I went to apply for Colonial, one of the questions on the application asked, did you have a criminal record? And at that point, I was done with my probation. I paid back money. I didn't have anything else on my criminal record. There was nothing else out there. I said no, because I really needed the job. And they hired me. And I worked there for 10 years.
So just to be clear, they didn't fire you because of the criminal record?
No, they fired me because I had lied on the application.
And Ms. Carter, before that, were you ever convicted of any crime? Before 2004, were you ever convicted of any crime?
No, that's the only blemish on my record.
And since then, have you ever been convicted of any crime?
No.
Now, let's talk about your time at Colonial. You spent 10 years there.
Yes.
You said you're a pari-mutuel. Can you explain to the jury and to me what that is?
So it's a mutual teller. So it's a racetrack and it's a casino, and there's somebody that has to be there in the booth to take the bets and to pay out the winnings. that's the mutual teller. That's what I did.
And you also said you were a clocker. Can you
Yes.
explain that?
So a clocker is somebody that goes actually physically down to the racetrack and times the horses as they're warming up and they're running. It's part of their stats. It's how fast they're going with where their time is. So I was down kind of taking the times of the horses as they ran.
So as a clocker, you were physically on the racetrack.
Oh, yes.
You were spending time observing the other trainers.
I
As
was
well?
working with them, yes.
Was there any other training you received besides those two?
So besides being a clocker and a teller, I didn't receive formalized training, but I was in the process of trying to become an assistant starter for a casino racetrack.
Husband, was he an assistant starter?
He was.
So can you tell us what an assistant starter does?
Sure. So there's many different roles and parts when you're working at a racetrack. The assistant starter, they're primarily responsible for taking the racehorse that has just been led from the stables, taking that racehorse and loading it into the starting gate prior to the race.
And what would happen if they didn't want to enter the gate?
The horse?
Objection, Your Honor. Speculation.
Ms. Carter, have you ever observed a horse not get into the gate?
Oh, yes.
Can you explain what you saw?
So horses,
Objection, Your Honor. Lack of personal knowledge. Mrs. Carter hasn't been employed at Colonial Racetrack for more than a decade.
Well, in general, have you experienced or seen personally what happens when a horse doesn't go into the starting block?
yes, Your Honor.
Or who would?
You can explain, Ms. Carter.
Sure. So horses don't like going into a tight, closed, narrow space typically. They have to be trained. They have to be conditioned to be comfortable doing that. So when you have a horse that isn't trained and isn't comfortable going into that kind of a narrow space, they react. They're apprehensive. They rear up. They buck around. They fight going into the starting gate. And you see that all the time, especially with newer racehorses before they're ready to race.
And what would happen to those horses who just weren't ready?
So the way that Colonial had it, there were two categories, really. There were the racehorses that were ready to start in a race. They were on the starting list.
Objection, Your Honor. Sidebar.
I'm going to rule and deny, but I'll give you access to the record. But you're testifying as to what happened when you were there, so you don't know if there were any changes or anything.
That's correct.
All right, I'm going to allow for that, and then counsel you all can cross-examine.
The horses that were ready to race, they were put on the starting list. And then there was the schooling list, which is where all of the horses that were still in school, that were still being trained, that's where all of those horses were.
I'm now showing opposing counsel what has been previously marked for identification purposes as Exhibit B2. I'm now showing. May I approach the witness, Your Honor? Thank you, Your Honor. I'm now showing Cameron Carter what has been previously marked as Exhibit B2 for identification purposes. Ms. Carter, do you recognize this?
Yes, I do.
How so?
This is a text message conversation I had with my husband.
And is this a fair and accurate representation of the text messages on that day?
Yes.
And can you please establish which colors are your text messages and which colors are your husband's?
So this is the screenshot from his text messages. One is in blue and I'm in gray.
Your Honor, I'm now moving into evidence Exhibit B2 as Plaintiff Exhibit 1. Matt,
B1 is, B2, I'm sorry for the record, is now in evidence. You may publish it to the members of the jury, or you can have her publish it, or any exhibit that is introduced, I'm going to allow you to see it, and even during your deliberations, I will send you a transcript so that you'll have a more extensive review.
Your Honor, permission to publish the evidence as a blow-up for the jury?
Just remember that the blow-up is just demonstrative to the actual exhibit that you have in your hand.
Ms. Carter, just to confirm, Kenny is the blue message,
Yes, Kenny's in blue.
and you're in the gray.
Yes.
If you can please read through the text message for the jury loud and clear.
Sure. So it's about 8:03 in the morning. The text message says, "Wow," and I respond, "What?" He says, "I cannot believe this crap." I say, "Kenny, what the hell? What is wrong?" He says, "Nothing yet." And then he says, "Jamie put Southern Charm on the starters list." I say, "So?" And he says, "That's the horse I was telling you about, the young one."
And Ms. Carter, do you know the Jamie that Kenny is referring to?
Yes, Jamie Wright was the head starter at Colonial Racetrack.
Was he the head starter when you were working there?
She was.
And do you know who Southern Charm is, as Kenny is referring to?
Yes.
How do you know Southern Charm?
Well, Southern Charm was actually pretty famous throughout the casino and racetrack during that time. Southern Charm was a new horse that was purchased, I think, about a week before Kenny died.
Have you and Kenny ever talked about Southern Charm?
Yes.
When did you talk about it with Kenny?
Well, so Kenny actually called me on the day that Southern Charm was purchased and first introduced onto the racetrack. I was on the phone with him, and he was watching Southern Charm run around, and he commented about it's a beautiful horse, it was very fast, it was a young horse, and then he just went silent, like mid-thought, went silent. And then he said that...
Objection, Your Honor, you're saying.
Have you ever personally seen Southern Charm?
Yes.
When did you see Southern Charm?
I don't remember the specific date, but it was that week. I would go and visit Kenny at work all the time.
Your Honor, I'm now showing opposing counsel what has been previously marked as Exhibit 4 for identification purposes. May I approach the witness, Your Honor?
No objection, Your Honor.
I'm now showing Cameron Carter what has been previously marked as Exhibit B4 for identification purposes. Ms. Carter, what is this?
This is a screenshot of a text message conversation that I had with him.
And how do you recognize it as so?
Well, this is the last text message conversation that I had with my husband. I remember it.
And is that a fair and accurate representation of the text messages between you and your husband on the report?
Yes.
Your Honor, I would like now to move Exhibit B4 into evidence as Plaintiff Exhibit 2 for identification purposes.
Well, if it's in evidence and it's 2, it's evidence. It's not for identification purposes.
I'd like to move it into Plaintiff Exhibit 2.
Yes, and where is plaintiff exhibit 1? Needs to be. Kind of play down, just not the new exhibits. So this is plaintiff's exhibit 1, which was formerly B2. And you give me B4.
May I publish it to the jury, Your Honor, as a blow-up?
But just keep in mind, members of the jury, the blow-up is just for you to see. You're going to get the actual exhibits when you go to deliberate.
Ms. Carter, if you would please read the text message thread for the jury.
Sure. Jamie, so Kenny says, Jamie said the horse is ready. Gotta trust Jamie's judgment. Jamie is telling me Southern Charm. And I asked, so the race is going on? He said, yeah, Southern Charm makes 5, so we do not have a short field anymore. And I say, okay, let me know. I expect a text after Kenny. I said, I will, love you. He said, you better, love you more.
And Ms. Carter, he refers to a short field. Do you know what a short field is?
Yes, I,
How do you know what a short field is?
so working at the racetrack, but also working as a teller at the racetrack, you understand the lingo, what a short field is.
And the teller was the one collecting the bets at the casino?
Yes,
So if you had first-hand experience with the bets being placed,
yes.
can you please explain to the jury what a short field is?
Sure. So the way that it works at a racetrack is bettors place bets on when a horse will finish or in what order the horse will finish. There's different incentives for making larger, more risky bets. For example, a quinella. Quinella is a bet where you say, I think that these two horses will finish first. And it doesn't have to be the correct order. It could be 2-1 or 1-2, but you're making that bet on those two horses coming in first. If there are 10 horses or 12 horses racing, then the odds of winning are kind of allocated like that. It's a bit more of a higher risk. If there's 4 horses racing and you have a quinella where you're saying these two are going to come in first, obviously the odds of winning are much greater, and the odds of having to pay out large winnings to bettors is much greater. So a short field with less horses means that the people placing the bets have a higher odds of winning. It can be very expensive for the casino, so typically racetracks won't want to run a short field. They want to run multiple horses racing to even out the odds.
And we're not all familiar with better terms, so just to be clear, the more horses there are, the less likely chance a bettor has to win.
Yes, essentially.
And he refers to Jamie again. I want to confirm, is that the same head trainer of Southern Charm?
Well, Jamie was the head starter at the race course.
Ms. Carter, I just have a few more questions. Do you know who owns Colonial?
Yes,
Who owns Colonial?
Frank Fonsetti.
No, Frank Fonsetti.
I worked for Frank Fonsetti. Kenny worked for Frank Fonsetti.
How would you, in your experience, describe the Mr. Fonsetti's management style?
I would say that as a boss, he was very hands-off when it came to his employees, his staff. He wasn't very friendly. He wasn't very warm. He was really about the bottom line.
Do you have any examples of that?
Oh yeah, thousands. Okay. So I wanted to be an assistant starter. I had started the process of training. It's a very hands-on position. So you're down there, you're with the horses. You have to be confident in handling the horses. It's
Objection, Your Honor. So, Your Honor, this has already been pre-stipulated, pre-trial. This court is going to heard a motion in limine from the defendant. The motion in limine was to deny Mrs. Carter the ability to speak as to training procedures of horses. That motion was granted by this court, and it goes in Ms. Carter's testimony.
I granted the motion as to having her declared an expert. She's not testifying as an expert. She's testifying to her own personal experience. But she says she's got thousands of examples, counsel. Just give this jury just one overview.
We just need one, Ms. Carter. Sorry, Your Honor.
Okay. So an assistant starter, that's a professional position. People go to school for that. They train for that, and you have to pay professional people professional salary. But Mr. Fonsetti decided that would be a more appropriate role for a high schooler with no training.
Objection, Your Honor. Speculation.
I'm going to sustain that. You can't say what Mr. Fonsetti was thinking of doing.
That high schooler, do you know what grade he was in? I mean, the high school, that employee was in high school.
That employee was in high school.
And did he have any experience in horse racing?
Objection,
In your
Your
personal
Honor.
knowledge?
Again, speculation.
Well, do you know about the high schooler's experience?
Yes, Your Honor.
All right, well, we'll go.
The high schooler that Fonsetti hired as an assistant starter had no experience with horses.
He was assigned to be part of the starters crew.
He was.
Starters crew, in your experience, is it a dangerous type of job?
Absolutely it is.
So it was an inexperienced high schooler working in a dangerous job, in your opinion.
Yes, and I don't understand why a high schooler got that job.
Ms. Carter, after this whole incident and when Kenny died, did anyone from Colonial reach out to you?
Jamie Wright reached out to me.
Jamie Wright, the head starter.
Yes.
Was Jamie Wright the one who placed Southern Charm on the starters list that day?
From my understanding, yes. Jamie Wright as the head starter is the only one who could have moved a horse from the schooling list to the starting list. And according to what Kenny texted me, Jamie assigned Kenny to load Southern Charm into the gate that day.
And what did Miss Wright tell you?
She told me that she wished
Objection,
she had
Your
done
Honor,
things
hearsay.
differently.
No further questions, Your Honor.
Yes, Your Honor.
You may proceed. And here are the exhibits that were introduced if you. Before we have cross-examination, everybody take a deep breath. Entree, Steve, please.
All right.
Thumbs up.
1 second.
All right, members of the jury, we've been having technical difficulties with the mics here in the courtroom, so please forgive us. I'm trying. All right, ladies and gentlemen of the jury, I'm going to ask for your indulgence. I apologize for the many breaks and recesses we've had to take. We've had some technical difficulty with the microphones here in the courtroom, but I will assure you we're working on it to try to keep us at an even pace. So do the best you can with keeping up with us. Cross-examination, counsel, you may proceed.
Yes, Your Honor. Good evening, Mrs. Carter. Just have a few questions for you. Mrs. Carter, how long were you married to your husband?
10 years.
I'm sorry for your loss, Mrs. Carter. My condolences to you. Mrs. Carter, you said you previously worked at Colonial, correct?
Yes.
How long did you work there?
I worked there about 10 years.
You were terminated at Colonial because of an issue with your employment application, correct?
Yes.
Mrs. Carter, you spoke a little bit about horse racing. You would say that horse racing is dangerous. It's a dangerous sport.
It can be, certainly.
It can be a dangerous sport. Okay. Mrs. Carter, would you say that your husband was aware that racehorse is a dangerous sport?
Yes, which is why he was very careful and he took his job very seriously.
This was his passion, right? He was very dedicated to his job.
I would say so, yes.
Mrs. Carter, would it be out of the ordinary for your husband not to wear his racing helmet and his equipment?
I don't know what you mean.
Objection, speculation.
Although, but she didn't understand the question, so
I will rephrase the question, Your Honor.
thank you.
Mrs. Carter, as is been talked about a little bit here, there's safety equipment that you have to wear when you're an assistant starter. You remember taking the deposition earlier before this whole trial?
Yes?
You talked a little bit about it in there, actually. Would it be out of the ordinary for your husband not to wear the racing helmet and flak jacket that was required of him?
Would it be out of the ordinary for him
Yes.
not to?
Yes.
Many of the assistant starters either wore their flak jacket or their helmets or didn't wear their flak jacket or their helmet. It really wasn't that tightly run of a ship.
But it was part of the rules, wasn't it? You worked there for 10 years. You knew about the rules and procedures.
Sure, it was part of the rules and procedures, but it wasn't something that was strictly enforced nor strictly followed.
Whose fault do you think that was?
I would imagine that it's Colonial's fault.
Is there a
The way that-
specific person? Do you know who was in charge of enforcing the rules?
Well, I would say Frank Fonsetti would be in charge of his racetrack and casino.
Are you familiar with Mr. Chaney Wright?
I do know Miss Chaney Wright.
And Mrs. Chaney Wright, she was the head starter, correct? She worked with your husband for many, many years.
She did, yes.
Would it surprise you that Mr. Wright was the enforcer of the rules at Colonial Racetrack? Since he had eyes on the racetrack, of course.
Counsel, that would be Miss Wright.
I'm pardon
Miss
me,
Wright.
Your Honor, I didn't hear you.
Miss Wright.
Okay, I'll read
She's a
this.
female, Jamie.
Yes, yes, apologies. You can continue answering this.
What
Would
was
you
the
like me to
question?
rephrase the question?
You can repeat the question, thank
Yes.
you.
Mrs. Carter, are you aware that Mrs. Wright is one of the parties responsible for enforcing the rules at Colonial?
Yes,
You would say that your husband trusted Mrs. Wright.
yes.
What was the relationship between your husband and Mrs. Wright?
I mean, everybody who worked there was like a big family.
So it was a close, tight-knit group.
Yes.
Mrs. Carter, what's your relationship with Frankie Fonsetti?
I don't have a relationship with Frankie Fonsetti.
Why is that the case?
Well, I no longer work at Colonial.
Because you were terminated, correct?
Yes?
Would you say that your termination was just an application of the rules? It wasn't anything personal, right?
No, I don't think it was anything personal.
Do you have any sort of animosity towards Mr. Fonsetti for having to follow the rules and terminate you at the track?
I don't understand why lying on an application 10 years earlier when I had 10 years of consistent
But it is part of the
quality
rules, isn't it, Mrs. Carter?
was-
You either apply the rules or you don't.
What's part of the rules?
Part of the rules is that you don't lie in your employment application, that you're truthful.
No, I admitted that I lied on my application, but that was 10 years before they fired me.
But you still lie in your application.
Yes.
Okay. Mrs. Carter, excuse me, Your Honor, I'm just collecting my thoughts for a second. Mrs. Carter, just want to go back to one thing quickly before I conclude this line of questioning with you. If your husband didn't wear his helmet, didn't wear his flak jacket, and you didn't follow the rules and procedures, how could the defendant possibly be responsible for his death? As tragic as it is.
The defendant, Frankie Fonsetti, decided that profits were more important than the safety of his employees and the safety of his people. And when he
And
was
Mrs.
at the
Carter-
risk of running a short field, on the day that my husband was killed, he elected to put a horse in the starting line that wasn't ready, that was terrified of the starting gate, that every single person who worked there knew was not ready to go into the starting gate, and he decided that it was more important to him to save money on bets than to protect my husband. And
Mrs.
that
Carter.
was his decision.
Mrs. Carter, with all due respect to you and your loss, you don't have any evidence of any of this happening, right? You were no longer part of Colonial Casino and Racetrack. It is a tight-knit family, but you've been part of that tight-knit family for 10 years, correct?
I'm sorry, what is your question?
You did not have any personal knowledge of this, Mrs. Carter, correct?
I'm sorry,
You didn't
personal
have any
knowledge.
personal knowledge that Mr. Fonsetti did what you're accusing him of doing. That
That's
Mr. Fon-
absolutely what he did, absolutely what he did.
Well, what evidence do you have that he did that?
He is at risk of running a short field. He would lose a lot of money. And there was a horse that was at the racetrack for 5 days.
How would
was
you know
terrified
that
of
if you
the
didn't work
start-
at the racetrack anymore, Mrs. Carter?
Because I was there and I knew it, and Kenny told me.
Did you see Southern Charm?
I did see Southern Charm, yes.
What did you see?
I saw a horse that wasn't ready to race.
Ms. Carter? Oh, excuse me. Allow me to confer with my counsel. When you were at the racetrack, Mrs. Carter, you weren't there in a professional capacity. You were just there as an observer, correct? You were ready to terminate it.
I was there.
Objection, compound question, Your Honor.
You understand the question?
Yeah.
Oh,
I was there visiting my husband.
One final question, Mrs. Carter, for you. How can you attribute responsibility to Mr. Fonsetti? How do you not hold any sort of resentment towards him when he had terminated you?
I'm sorry, I'm confused. Are you asking about Kenny's
Counsel, bring the
death?
question up, so she
I can
knows
bring the
what
question
it
up.
is.
I'll read
Yes.
the question. Mrs. Carter, you said you don't hold any animosity towards Mr. Fonsetti, correct?
I said I don't take it personally.
You don't take it personally. Yet, even though you don't work at the racetrack anymore, even though you don't have any evidence of the statements you're making, you say that it was Mr. Fonsetti who was responsible for decisions involving Southern Charm.
It was his racetrack. It was his loss if he ran a short field.
No further questions, Your Honor.
Read back. And I'll limit it to only new areas. Do not rehash what was asked on direct and cross.
There's no further questions, Your Honor.
Thank you. Mrs. Carter, you may sit down. Thank you. Next witness, please.
Yes, we're going to call Blake Bauer to the stand, Your Honor.
Blake Bauer. Please remain standing, and I'll swear you in. Please raise your right hand. You swear?
I swear.
You may proceed. You may proceed.
Thank you, Your Honor. My apologies. Good evening, Mr. Bauer. How old are you, Mr. Bauer?
Hold on a second. When I asked him to state their name and spell the last name, it was asked again, so we'll establish that. Please tell the members of the jury your name and spell your last name for the record.
Blake Bauer, last name B-O-W-E-R.
Now you can inquire.
Thank you, Your Honor. How old are you, Mr. Bauer?
I'm 46.
And what do you do for a living?
Well, I'm currently a freelance racehorse trainer.
Do you have any formal education in horses?
Yeah, I have my associate's degree in equine studies.
And how long have you said you were doing freelance racehorse? About how long have you been doing that?
I've been doing that ever since March 24th, 2018.
Where were you working? You mentioned March 24, 2018. Where were you working on that day?
Back then, I was working at Colonial Racetrack.
And how long did you previously work for Colonial?
About 30 years, most of my life.
What positions did you have at Colonial?
Well, I started back in high school cleaning the stables and grooming the horses. Then I became a pony rider. Once I got my degree, I became an assistant trainer, and then I worked my way up to head trainer.
How long did you have the head trainer job for?
15 years before I resigned.
Could you tell us what some of the responsibilities of that job were?
Well, the responsibilities of a racehorse trainer is basically everything to get the horse race ready. I would analyze the horses when they came in to see what they needed to work on, and I would train them based off my analysis.
Now, we're going to break down your analysis. How do you analyze the new horses?
Well, the first thing we do is we start with lead training.
Could you explain what lead training is to us?
Well, it's important to familiarize a horse with yourself so they know who to listen to and they can pick up on simple commands.
And why is it important?
Well, horses have very strong personalities, and it's important that they know who's training them so that they can listen to only that person.
So, what happens after lead training?
After lead training, then we have saddle training, which is where they get comfortable wearing all the equipment, and after that, then they get used to having a rider on them.
Is there any training after that?
Yes, then we have to gate train them.
What's gate training?
Gate training is just when we get them used to loading into the gates.
I'm going to show opposing counsel what has been previously marked as Exhibit H.
You may.
And may I approach the witness, Your Honor?
You may.
Thank you. Mr. Bauer, do you know what that is?
Yes, this is a horse's starting gate.
Is that the same gates that Colonial uses?
It's not the exact one, but it is identical.
So, you mentioned gate training. If you could break down why gate training is important for us?
Well, gate training is important because it's against the
Objection,
horses.
Your Honor.
Basis?
This has not been moved into evidence yet, and the witness is now opining upon the subject and materials.
My apologies.
You gonna move it in? He can still answer the question as to why it's important without moving it in, but if you're going to move it in, this would be the time, and if you want to publish it, that'd be better.
Thank you, Your Honor. At this time, we'd like to move what has been previously marked as Exhibit H into evidence as Plaintiff's Exhibit H.
That'd be Exhibit 3.
Thank
And
you.
if you'll give it to the court, I'll mark it, and then you can show it to anybody in the courtroom you so desire.
Do I have permission to publish the
You
exhibit?
may.
And may I publish it in the form of a Ilona
You
image?
may. Keep in mind, members of the jury, that when you go to deliberate, it will be the hand held as opposed to the blow up.
Now, getting back on track, you mentioned gate training earlier. Why is gate training important?
Well, it's against a horse's nature to be confined into a tight space, and as you can see, that space is very tight for a horse.
How do you get the horses into the gate?
We start by familiarizing them with the gate without closing the door behind them. We repeat that as many times as they need until they're comfortable.
What happens if the horse just never gets comfortable?
Well, we have a couple different techniques. We'll either put a blanket over their eyes, or we'll have 2 assistant starters slowly guide them into the gate.
Now, where does the assistant starter go after they've loaded the horse?
He goes and sits up on those things on the left called the pontoons.
These over here?
Yes.
Now, once a horse learns to get loaded into the gate, is gate training, or is training over for the horse?
No, we then also need to get them comfortable with the gate closing behind them, standing there with the other horses, and exiting the gates at a starting pace.
Is there any other training involved?
Yes, then of course we have conditioning. Training is a very long process.
About how many horses would you say you've trained in your career, Mr. Bauer?
Hundreds, way too many to remember.
In your experience, about how much training is given to each horse?
Well, it depends on my analysis of the horse. Sometimes we get a horse with a bunch of experience and they need less training, and sometimes we get a brand new horse that needs a lot more training.
Could you give us an average about how much training each horse would require?
Yeah, about 3 to 5 weeks is average.
Now, besides observing a horse directly, is there any way that you can determine how much training a horse has?
Yes, before the horses even arrive, we learn a lot about the horses by looking at their racing profile.
What's a racing profile?
It's basically a permanent record. It shows their lineage, their prior owners, as well as their career history.
I'm now showing opposing counsel what has been previously marked as Exhibit A. May I approach?
You may.
Do you recognize that, Mr. Bauer?
Yes, I do.
What is that?
That is Southern Charm's racing profile.
His most recent one?
Yes.
At this time, we'd like to move Exhibit A into evidence.
Objection or pulled out?
Yes, Your Honor. Objection under 401 and 403, relevance and prejudice.
Well, the court has reviewed the exhibit. I'm going to overrule the objection. Exhibit A, which is a composite two-page exhibit, is now in evidence as Plaintiff's Exhibit 4. If you'll give it to me, I'll mark it. And
Your Honor, may I be heard on the matter?
I heard enough pre-trial counsel, but I'll give you access to the record once we take a break. You'll pass that over to the court, and I'll mark it.
I believe that's Plaintiff's Exhibit 4.
Yes, sir.
And permission to publish it to the jury as well.
You may do so.
Now, Mr. Bauer, I know it was just taken from you, but did you recall? Yes. You could have turn your attention to the last page. What racetracks does it say Southern Charm is affiliated with?
Just Colonial Casino and Racetrack.
Any others?
No.
Now, in your experience, would that indicate a lack of any training prior to coming to Colonial?
Yes.
So had Southern Charm raced at all before coming to Colonial?
No.
Had he trained at all before coming to Colonial?
No.
Thank you. Now, were you familiar with Southern Charm before the March 24, 2018 accident?
Yes, I was.
How were you familiar with that?
I was his assigned trainer when he first arrived.
Do you remember how old Southern Charm was when he first arrived?
Yes, he was only 2 years old.
Is that old for a horse?
No, it's very young.
Now, did Southern Charm ever give you any problems when you were training with him?
Oh, yes.
Like what?
Well, for one, that horse hated loading into the gates, and even if he would load in the gates, he was unhappy to be in there, and an unhappy horse is very unpredictable.
About how long did you train Southern Charm?
Not very long, just a couple days.
What happened after a couple days?
Jamie Wright wasn't happy with how the gate training was going, and she wanted to personally take it over.
Do you know why she took over Southern Charm's training?
Yes, we were short on horses, and Southern Charm was young and fast, and they wanted him out on the track.
What did you think when Jamie Wright took over his training?
I thought it was a bad idea.
Why did you think that?
Well, not only did Jamie Wright take over the training, she also had every assistant starter working with Southern Charm as well. And like I said, it's important for the horse to know who's leading them, or they won't know who to listen to, and that can be dangerous for everybody around.
Did you advise Miss Wright against this approach?
Yes, of course.
Now, in your opinion then, did Southern Charm have a consistent trainer before he was allowed to race?
No.
I'm now showing opposing counsel has been previously marked as Exhibit C. May I approach the witness, Your Honor? Do you recognize that, Mr. Bauer?
Yes, I do.
And what is that?
This is a copy of a portion of Colonial Casino and Racetrack's policies and procedures.
And those are the same procedures that were in effect when you were working there?
Yes, they were.
We'd like to, at this time, move this into evidence as Plaintiff's Exhibit 5, I believe.
Pulled out?
No, Your Honor, no objections.
Then Plaintiff's Exhibit 5 will be marked, and you may publish it.
And do I have permission to publish it as a blow-up, Your Honor?
You may.
Thank you. Now, Mr. Bauer,
If you can't see that form, Mr. Bauer.
turning your attention to Part A of these policies, what does it say there in regards to the duration of gait training that a horse would receive at Colonial?
It says that horses will remain on the schooling list as long as necessary to demonstrate the horse's consistent ability to safely enter and exit the starting gate.
How many times did Southern Charm load without an issue in the week prior to the March 24th race?
Never. It was always one issue after the next.
In your opinion, then, in your experience in working with Southern Charm, would you characterize his training as consistently loading in the week leading up to the race?
No, absolutely not.
Now, turning your attention to Part B, what are the requirements for placement on the starters list?
Horses must demonstrate sufficient competence in loading into, standing in, and exiting from the starting gate before the horse may be given a gate card and placed on the starters list.
Now, in your experience, did Southern Charm fulfill the necessary qualifications to be placed on the starters list?
No.
How long does an average horse need to train before they run their first race?
About 3 to 5 weeks is average.
And how long was Southern Charm trained before his first race?
Objection, asked and answered.
I'm going to sustain that.
In your experience, have you ever seen a horse be allowed to race after only 1 week of training?
No, never.
Now, were you working at Colonial the day that Mr. Carter was killed?
Yes, I was.
When that day started, was Southern Charm on the starters list or the schoolers list, the schooling list?
He was on the schooling list.
So was Southern Charm supposed to race that day?
No, horses on the schooling list are not supposed to race.
Why not?
Well, they lack training, just like Southern Charm, he lacked training.
Were there other horses that day that were supposed to race?
Yes, there was.
What happened to them?
They got sick and they had to drop out of the race.
So how many horses were left after those sick ones were gone?
4.
Now, if Southern Charm didn't join the race, would you characterize that as a short field?
Yes, that would be a short field.
In your experience at Colonial, do they typically run short fields?
They do everything they can to avoid a short field.
Why is that?
Well, a short field typically means less money.
So then was it your decision to have Southern Charm race that day?
No, it was not.
Who made that decision?
Jamie Wright, the head starter.
So, on the day of the race, not the week leading up, on the day of the race, did Southern Charm load successfully?
Well, on the day of, yes, actually Southern Charm loaded.
Oh, so if Southern Charm loads successfully on the day of the race, are they good to race?
No. Just because they loaded on the day of the race does not mean they're ready. A horse is still inconsistent after one morning of loading.
What did you do when you found out Southern Charm was going to race that day?
I told Jamie it was a bad idea.
What did he say to you?
He said, I don't know.
Objection, calls for hearsay.
Sustain.
May I proffer an exception?
I'll give you access to the record, but please move on and ask your next question.
Now, why did you leave Colonial Racetrack, Mr. Bowers?
I resigned.
Objection, relevance, character evidence, 4042.
I resigned because I couldn't support the business anymore. My friend's death was totally preventable, and I just couldn't support them anymore after that.
Okay, we have no further questions for the witness, Your Honor.
Cross-examination.
Yes, Your Honor.
You may proceed. And if you need the exhibit, Mr. Bowers has them on the stand.
Mr. Bowers, you've been working with horses for 30 years, right?
Correct.
You were trained by one of the best.
Yes.
And so you learned that all horses are different.
Correct.
Some need more training,
Yep.
but some need less.
Yes.
And you told this jury that Southern Charm didn't load once correctly the entire week, right?
That I was training him? Correct.
Right. That was 3 days, correct?
Correct.
And we talked a little bit about the training that's required for a horse to get onto the starting list, correct? We talked about lead training.
Correct.
Southern Charm didn't have any issues with lead training.
Correct.
We talked about saddle training. There were no issues there.
Correct.
Conditioning with a rider, no issues.
Correct.
Conditioning without a rider, no issues.
Correct.
And on the day of the race, Southern Charm loaded over and over again correctly, right?
Yes.
And so there are some rules and policies at Colonial.
Yes.
There's some policies about loading the horse,
Correct.
and there are policies that every single person at Colonial, when working with a horse, has to wear a helmet,
Correct.
including the assistant starters,
Yes.
because they have the most dangerous job
Correct.
of loading those horses into that gate.
Yes.
But that's not the only rule Colonial has.
Correct.
You're also not allowed to slap the horses.
Correct.
But on the day of the incident, Mr. Carter slapped the horse, right?
I'm not sure. I didn't see it happen. I was in another stable.
Right, you were in another stable, working with another horse.
Correct.
So you couldn't see Mr. Carter.
Correct.
You couldn't see Southern Charm.
Nope.
So you don't really know what happened.
No, just from what I've heard.
And let's be clear, you've never liked Frankie Fonsetti, right?
I did not know.
And in fact, Jamie Wright, you wanted her job.
Yes, I should have had the assistant sorter's job, or head sorter's job.
Right, but when it came to loading and training Southern Charm, after 3 days, she took you off, right?
Yes.
Because she didn't think you were doing a good job, right?
Or because they wanted to make money for the track and I wasn't going to let the horse out after 1 week of training.
And just to be clear, these horses at Colonial, they're not trained for a petting zoo.
Correct.
They're not trained for a birthday party.
Correct.
They're trained to run as fast as possible
Yes.
the moment those gates open.
Correct.
And they can be dangerous.
Yes, they can.
Thank you. No further questions.
Read it back.
Yes, Your Honor.
No areas only.
Thank you. Now, there was some talk about safety here. And Colonial does have a policy about wearing flak jackets and helmets. Whose job is it to enforce that policy?
Jamie Wright is supposed to enforce that policy and make sure everybody is wearing the proper equipment, and if not, he's supposed to pull them from their duties.
In your experience there, does Jamie actually enforce that policy?
No.
So you've seen people without a helmet,
Yes.
and you've seen Jamie not tell them to put it on?
Yes, he even says, if you want to take the risk.
Objection. Calls for hearsay.
Sustained.
May I proffer an exception, Your Honor?
Not at this time, counsel.
So then in your experience, would Jamie make team members who weren't wearing safety gear put it on?
No.
Now, there were some talks about Southern Charm satisfying other aspects of the training. But I believe you did mention the problem with the lead training. Did Southern Charm have a consistent lead trainer?
No.
And let's say a horse has satisfied all of the training requirements besides gait training. Is that horse safe to race?
No, they need to hit every exception for all training.
Thank you. No further questions.
Thank you, Mr. Bowers. Thank you for your presence. Your hand those exhibits back to the court. I'll put them here so counsel can get them. Thank you. I think there was a, we gave you back. All right. Does the plaintiff have any further witnesses?
Yes, Your Honor. At this time, we would like to read in part of a sworn statement. That it would be the sworn statement of Danny Mahan. Specifically, we are going to read in the the final paragraph.
Does the defense have a copy of that statement?
We do, Your Honor.
Anything before the statement is read?
Your Honor, just to clarify, due to a pretrial stipulation, the only portion that will be allowed in is the final sentence of the statement.
That is the portion that we intend to read.
All right. You may do so. Just read that into the record. Members of the jury, you're about to hear a statement made by a person that is not going to be called into the courtroom to testify. I want you to listen carefully to what is read to you. However, the same rules apply. You can believe all or any part of what's read to you. You can believe all, some, or none. That is the province of this jury. You may proceed at this time.
Thank you, Your Honor. It appeared from the immediate severe bruising to the left temporal region of Carter's face between his left eye and left ear that he had suffered significant blunt force trauma.
Anything further?
No, Your Honor. At this point, the plaintiff will rest its case in chief.
All right, members of the jury, we're going to take just a brief break. There's some procedural matters I need to take up with the attorneys. We'll take 5 minutes. Try to keep it at 5 because I want to keep us going. All right. All rise for the jury. Go out and get your men.
I don't think you're going to make it in time. I think it's going to take like 10 minutes.
All right, will the defense be presenting a case?
Your Honor, the defense is ready to proceed, but we do have one motion. You heard constructively outside the jury's presence.
Yeah.
Pursuant to Rule 50A of the Federal Rules of Civil Procedure, the defense moves for a verdict, a judgment as a matter of law. Specifically, when viewing the evidence in light most favorable to the non-moving party, no reasonable jury could find a verdict in favor of the plaintiffs. Specifically, when looking at breach, the plaintiffs have failed to establish that. In fact, the opposite. We've established that there are policies and procedures at Colonial. Those policies require all employees to wear helmets. And on the day in question, Mr. Carter did not wear his helmet. And as such, we respectfully ask this court to grant our motion.
All right. Here, briefly from the plaintiff.
Yes, Your Honor. Although we've established that there's policy, although we have established that there's policies and procedures in place, we've also established that the defendant, at least according to the former employees, was negligent in both enforcement of the policies and allowed them to either just not enforce them or they permitted willful violations. As such, there's definitely reasonable evidence that any reasonable jury could find liability on this issue.
All right, the court, having heard the evidence presented during the case in chief of the plaintiff, I do find that there are factual issues that have to be determined in this matter, and therefore the triers of fact, which are the jurors, they need to make that decision and not this court. All right, so the motion for directed verdict, or verdict in favor of the defense is denied by the court. All right, call your first witness.
Your Honor, the defense calls Frankie Fonsetti to the stand.
Frankie Fonsetti, please approach the witness stand. Raise your right hand. You swear?
Yes, sir.
Please be seated. Tell the members of the jury your name and then spell your last name.
My name is Frankie Fonsetti, Fonsetti.
You may inquire.
Thank you, Your Honor. Good evening, Mr. Fonsetti. Mr. Fonsetti, where are you from?
I'm actually local. I'm from here. I grew up in Washington, and I spent most of my life here.
What do you do for a living?
I'm the proud owner of Colonial Racetrack, and I own a few other racetracks.
How did you come to own a racetrack?
Well, it's a generational thing for me. I had the businesses in my family for 3 generations. My grandfather started it, passed it down to my father, and once he passed away in a car accident, tragically, I took over the mantle, and I've been running Colonial Racetrack and the other 2 for more than 3 decades now.
So it's a family business?
Yes, it is.
Mr. Fonsetti, what goes into owning and operating a racetrack?
There's a lot of things. Like I said, I'm the owner, so I gotta make sure that I'm making sure the place is running and open. I look into budget analysis, cash flow, inventory, stuff like that, making sure we're bringing in business and stuff.
Mr. Fonsetti, do you have any sort of formal or technical education with regard to owning and operating a racetrack?
Formally, none. I've been working on the racetrack since I was 7 years old. I spent every summer since I was 7 learning from the jockeys, the starters, and stuff like that. But formally, I don't have any trainings.
So like a long apprenticeship?
Yes, exactly. Life is the best teacher. So.
Mr. Fonsetti, I want to shift to March the 24th, 2018. Where were you on March the 24th, 2018?
The night before, I stayed in my office. I slept on the office couch that night. So in the morning around 6 a.m. I woke up, got ready, I took a shower in my office, and was down by 6:30.
Why did you have to stay in the office that night? Proceeding.
I was working on some cash flow and budget analysis for reports that night, and by the time I finished, it was too late to drive home. So, and I crashed in my office. Like, I do that occasionally. Like, if I have to put in the extra hours after work, at the end of the day, it is my own business. So, if I need to put in the extra hours after work, I'm willing to do it.
Your team comes first?
Yes, I have a lot of people that depend on me. My personal family depends on me, but I also have my employees that depend on me. So, I got to put in the extra hours if I have to.
Mr. Fonsetti, are you familiar with Southern Charm, the horse
Yes.
at the center of this case?
Yes, I am. Southern Charm was a great horse that we had. Spectacular horse. He was around 2 years old, a fascinating horse.
Oh, he was an up-and-coming horse?
Yes, for sure.
But you weren't the trainer of this horse. There was someone else, right?
Absolutely not. I'm not the trainer. I'm just the owner. I don't train horses. Jamie Wright is our head trainer.
Jamie Wright, you said, is your... What's Jamie Wright's role again? Pardon me?
Head starter, sorry.
Jamie Wright is your head starter. Mr. Fonsetti, how long has Mr. Wright been employed with you?
more than a decade now.
You would say you trust Mr. Wright's judgment.
Oh, absolutely. She's one of the best we have, and that's why she's got the job.
Your Honor, I'm going to approach defense counsel and show them what is the pre-marked exhibit. Your Honor, permission to approach the witness. Mr. Fonsetti, what have I just handed you?
It's a picture of the safety helmets that all our starters are required to wear.
And the picture has an exhibit?
Yes, Your Honor, it's Exhibit J, pre-marked Exhibit J. Mr. Fonsetti, can you please repeat yourself?
This is a picture of the safety helmet that is company provided and it's required for all our employees to wear while they're on duty.
Why is this safety helmet important for your employees?
Well, you gotta keep in mind, we're in the horse racing business. Inherently, it is a dangerous sport. These are extremely powerful animals. They're 1,000 pounds, so you gotta ensure that you're taking adequate precautions to ensure your own safety when dealing with them, especially when you're a starter, because when you're loading these horses into the starting gate, it's a very tight and confined spot. So, and these animals have a first instinct to run. So you need to make sure that you adequately take the precautions to protect yourself.
Your Honor, the defense moves to enter into evidence. Defense is pre-marked Exhibit J.
Would I or objection?
No objection, Your Honor.
Right, defendant's exhibit J for identification is now in evidence as defense exhibit 1, and if you give it to me, I'll mark it.
Your Honor, the defense asks that the Exhibit J be published as in blow-up form.
You may do so.
Thank you, Your Honor. Mr. Fonsetti, can you see this racing helmet?
Yes, I can.
This is the racing helmet that's used at Colonial, correct?
Absolutely.
This is the piece of safety equipment you said is vital for your employees?
Yes, and it's company provided.
This is the certified racing helmet?
Yes, it is certified.
It's a non-negotiable for you, for your employees to wear this helmet, correct?
Oh, definitely. Employee safety comes first, is non-negotiable.
Your Honor, I'm going to be showing the opposing counsel what is pre-marked as defense exhibit B. Your Honor, permission to approach the witness?
You may.
Thank you, Your Honor. Mr. Fonsetti, what have I just handed you?
It's a portion of our safety equipment. It's the policies and procedures for our employees.
Is this an accurate representation of the policies and procedures of your racetrack? A portion, at least.
Yes, it is.
Your Honor, the defense moves to enter into evidence. Defense is pre-marked Exhibit D.
Objection, or deny it?
There's no objection, Your Honor.
That is now in evidence and handed to the court.
Mr. Fonsetti, can you please hand it to her
So,
Honor?
marking defendant's exhibit 2 in evidence.
Thank you, Your Honor. Your Honor, permission to publish defendant's Exhibit 2 as a blow-up image.
You may.
Mr. Fonsetti, these are the rules and procedures we were talking about, correct?
Yes, that's correct.
Mr. Fonsetti, can you please recite what Section 3A of the Rules and Procedures titled Protective Gear states?
You want me to read it out?
You can read it from there if that's more convenient for you.
Okay. It says any staff members exclusive of
If you speak into the mic, Mr.
Oh,
Fonsetti.
sorry. Any staff members exclusive of jockeys on race day mounted on a horse or stable pony while on the grounds must wear a properly secured helmet and safety vest at all times. Additionally, all members of the starting grade crew must adhere to this policy while performing their duties or interacting with the horse in any manner. All helmets must be ASTM-SI certified.
Mr. Fonsetti, this rule is vital to the protection of your team members, correct?
Yes, absolutely. That's what we have in place.
Mr. Fonsetti, do you know if Mr. Carter wore his protective gear on that day?
He did not.
He did not wear the helmet.
No, he did not.
He did not wear the flak jacket.
He did not.
So, in essence, Mr. Carter violated the rules.
Yes.
Mr. Fonsetti, how long was Mr. Carter employed at Colonial?
About a decade.
So Mr. Carter was a well-experienced member of your team.
Yes, he was an experienced member.
And Mr. Carter was aware of and would have known that these rules were for his safety.
Yes. With his experience, he should have known. He would have known.
No further questions, Your Honor.
Cross-examination.
Yes, Your Honor. Thank you. Well, continue on this discussion about Exhibit D. Who's supposed to...
It's Exhibit 2 in evidence. Defense Exhibit 2 in evidence.
Thank you, Your Honor. Do you personally enforce this policy?
No, Jamie Wright does.
All right. So you don't go over with staff what they're supposed to do?
Well, all staff members get a copy of it.
But you don't make sure they read it, you don't read it to them?
Well, counselor, you gotta keep in mind, I'm the owner, and I have 3 other businesses, so I can't side manage everyone.
No, you're a busy man. You leave enforcement up to Jamie, right?
Yes, Jamie Wright has full discretion.
Do you know, but you don't know how Jamie enforces the policy?
If she has any issues with it, she can bring it up to me.
Now, turning your attention to Defense Exhibit 1, you said that this is the helmet, right?
Yes, it is.
This is the helmet that they wear at Colonial?
Yes, it's company provided.
Now, just kind of common sense, this part in the front here, that's, you look out that way, right?
Mm-hmm.
Now, would it make
You
sense?
have to say yes or no, you can't say...
Oh, sorry, yes.
Now, would it make sense if this helmet covered the person's eyes?
Well, you gotta keep in mind, it's approved by the American Society of Material Testing, so it's not up to me, but it's approved and certified.
Thank you for that, but my question was about the person wearing this helmet.
Mhm.
Does the front part, would it go over their eyes? Does that make sense to you?
Objection, Your Honor.
What's your
Very
question?
ambiguous.
I'm gonna sustain whether it makes sense to him. You can ask, rephrase the question.
Now, helmets are supposed to protect your head, right?
Yes, that's correct.
So, if you wear a helmet, you need to see.
Mhm.
So this
You
helmet,
have to say yes or no.
Oh, sorry, yes.
this helmet, would it cover your eyes?
No, it wouldn't cover your eyes.
And so this part would be above your eyes.
Yes, it would be.
And do you agree that the shape of this line is straight?
Yes.
So if this part's above your eyes, could you indicate to the jury where it would be?
Probably midway to your forehead.
So if this part is straight and this part goes over your eyes, it stands to reason that, you know, if it starts here, it goes straight here.
Yes.
So does this area cover the area in between your eye and your ear?
No.
So if somebody was wearing their helmet and they got hit in the area in between their eye and their ear, they wouldn't be protected.
They wouldn't be, that's right.
So if Jamie Wright got hit in the area in between his eye and his ear, it doesn't make a difference whether he was wearing his helmet at all, does it?
Jamie Wright did get hit.
Objection, Your Honor, calls for an improper conclusion.
Well, first of all, counsel, please do not mix up the names Jamie Wright.
I apologize, Your Honor, yes.
So I'm going to sustain the objection that is to the wrong person.
Right, and I have no further questions on cross.
All right, read back.
Yes, Your Honor,
Only
thank you.
into new areas, counsel.
Mr. Pinsetti, you pride yourself in how you run your racetrack, correct?
Yes, that's correct.
It is a guiding light for you, correct?
Yes.
Relevance as well as outside the scope of cross.
Sustain.
Understood, Your Honor. Mr. Pinsetti, if you don't wear a race helmet, it can't protect you, right?
Yeah, absolutely, that's why they're there. to
If you
protect
don't wear a flak jacket, it can't protect you, right?
Yes, that's correct.
And even though you enforce the rules, it is incumbent ultimately on the employee to make sure that they're wearing your safety equipment, correct?
Yes, for sure. And in the case of Kenny, he was experienced employee, so he should have known on his own to wear them.
So Kenny would have known this again.
Yes, like he worked there for more than a decade, so he should have been aware.
No further questions, Your Honor?
Mr. Fonsetti, thank you for your presence here in this chapter. Next witness, please.
Your Honor, at this time we call Jamie Wright to the stand.
Ms. Wright, please approach the witness stand. Raise your right hand. You swear?
I do.
You may be seated. Please tell the members of the jury your name and spell your last name for the record.
Hi, I'm Mrs. Wright, just to set the record straight, W-R-I-G-H-T.
You may inquire.
Miss Wright, where are you from?
I was born and raised in Washingtonia.
What do you do?
I'm a head starter at Colonial Racetrack.
Were you always the head starter at Colonial?
No, when I started at Colonial 20 years ago, I started off as an assistant starter and I worked my way up to head starter.
In your opinion, what does an assistant starter do?
The assistant starter works and trains with the horses, and their primary duty is to load the horses into the starting gate on race day.
Your Honor, referring opposing counsel to what's already been moved into evidence as Plaintiff's Exhibit 3, the image of the starting gate. Permission to publish?
You may.
Permission for the witness to step down, Your Honor.
You may. Watch your step as you go down this way. And then counsel for the plaintiffs, if you all need to move to see what's going on, so they have access to do so.
That's fine.
Ms. Wright, what are we looking at here?
So this is the loading gate at Colonial Racetrack, or a picture of it.
How are these horses loaded into the starting gate?
So the assistant starter leads the horses head first into here, and the assistant starters stand on this on the left. It's called a pontoon.
Why do the assistant starters stand on this pontoon?
Well, it gives some protection from the horses. That way they're not going to get cornered in by the 1,000-pound horse.
What types of protections does Colonial have for those dangers?
So we have the pontoon, and we also have the helmets and the flak jackets.
Your Honor, the witness may return to the witness stand.
Thank you.
And you were telling us about these helmets. How are these helmets enforced at Colonial?
Well, it's on every assistant starter and employee to put the helmet on themselves. It's not in my official job role to tell them, but I do try my best to remind everyone because I want them to all be safe.
How do they receive these helmets? How do the employees get the helmets?
Colonial provides every employee with a vest and a helmet.
So how is an assistant starter any different than a head starter?
Well, as head starter, I do more supervising, and I also have the sole discretion of awarding the horses a gate card.
What's a gate card?
Well, it symbolizes that the horses are on the starting list that day for the race.
How would a horse receive a gate card?
Well, they get a gate card when they are loading into their gate consistently. It's up to me.
What would happen if a horse did not get their gate card?
Then they're not going to be racing that day.
And in your opinion, why would a horse not be given their gate card?
If they're biting, kicking, rearing up.
Explain to the jury what's rearing up.
Well, it's like you see in the movies where they get on their back legs and put their front legs in the air.
Ms. Wright, please describe the type of horses that come to Colonial for the jury.
These are race horses. They're beautiful and really powerful, and they run really fast.
And how else would you describe them?
They're like wild animals. I compare the job a lot to like those people at SeaWorld that ride on the killer whales. Like I said, they're beautiful and we can train them, but at the end of the day, they're wild animals.
So in your opinion, even with these precautions, are you ever fully protected?
No, I mean, we do our best. We have some procedures and policies and we work with the horses, but at the end of the day, it's a wild animal.
So Ms. Wright, I want to talk to you about the day in question, March 24, 2018. Where were you?
I was at Colonial Racetrack early that morning.
Why were you there?
I was working with Southern Charm and I was talking with the owner, Frankie.
Why?
Well, we had a short field that morning and I wanted to see if Southern Charm was well and worked with her, and I was also talking to Frankie about the virus that was going around with our horses.
Why would that be an issue?
Well, a short field means less money wagered and that's less business.
So what did you do?
Well, I advised that I thought Southern Charm was ready to race. She was loading very consistently that morning.
What about during the week leading up to this race? How was Southern Charm's training?
So at first, he was a little uncomfortable, and then he progressively got much better. By Thursday, he was showing great consistency, and then that morning it was perfect.
Were you the only one to work with Southern Charm?
No, Blake Bowers worked with her for 2 days.
Why only 2 days?
He wasn't getting the job done. He just didn't do what he was supposed to, and I just thought I'd be a better fit.
So once you approved Southern Charm for the starting list, what happens next?
So then I assigned Kenny to be the assistant starter for Southern Charm that day.
And as you told us, the assistant starters load the horse. How'd that go?
It was okay. Southern Charm looked a little bit uncomfortable at first, but eventually she got in there.
And what techniques does Colonial use when a horse is showing some hesitancy?
Well, typically the first thing we do is we have 2 assistant starters lock arms and get behind the horse to lightly guide them into the loading gate because you don't want to ever be directly behind the rear.
Was there any other techniques that Colonial teaches to use?
Yeah, sometimes the assistant starters can put a blindfold over the horse and lightly lead them in again with the gate open so they're comfortable.
Did Kenny use that technique?
No.
So what did Kenny do?
Well, at first he did try the locking arms one, and when that didn't work, it appeared that he must have been frustrated and he slapped the horse in the face twice.
So he slapped the horse. Is that a part of something that Colonial teaches their employees to do?
No, I've never seen that before in my life.
Are there any rules against this?
Yes, of course, it's completely abusive and appalling.
What rules, if any, does Colonial have that doesn't allow you to slap the horse?
Well, we have to treat all horses with respect and treat them as you would treat any animal. I mean, it's not directly written out because it's common sense.
It's in your policies and procedures, isn't it?
Yes.
And so after after Mr. Carter slapped Southern Charm, not once, but twice, how do you load?
Surprisingly, she went in. She loaded in the gate.
So did you start the race?
Well, I was about to when I heard a commotion.
And what did you hear, Miss Wright?
I'm not sure, but when I directed my attention that way, I saw Kenny on the ground and the EMTs were around him.
Did you call the EMTs?
No, they're always on the premises on race day.
So what happened to the race?
The race still happened with Southern Charm not on the list, so we ran with the short field.
Why did you run it with a short field?
Well, at the time, we weren't sure what was going on with Kenny. We didn't know the extent of his injuries, and so we continued to run the race just with the short field. People had already wagered their money.
And it wasn't the first time someone's gotten hurt at a racetrack, right?
Of course not.
Was Kenny wearing his helmet when you looked over?
No, he was not.
Allow me to clarify. When you saw Kenny after the incident with Southern Charm, was he wearing his helmet?
No, I did not see him wearing a helmet.
Thank you, Ms. Wright. No further questions.
Cross-examination.
Your Honor, if I could just have a few moments to gather the exhibits. Mr. Wright, on the day that Kenny died, you and Mr. Fonsetti had a conversation that morning.
Correct.
That conversation was about that race that afternoon.
Yes.
It was about the sick horses,
Yes.
about how there was only 4 horses that day.
Yeah.
And that's a short field.
Yes, that is.
And that's something you don't want.
We try to avoid it.
And after that conversation, there's 5 horses on the stars list.
Not directly after, but
But
yeah.
after.
Yes.
And the 5th horse was Southern Charm.
Yes.
So before the conversation, there's no Southern Charm.
Not exactly. I was working with her early that morning,
I'm
and I
asking,
was already thinking of putting her on the list.
you're already thinking about putting her on the list that morning?
Yes, when I was training with her, she was going perfectly into the loading gates and showing a lot of promise.
But before that morning, she had never loaded perfectly the entire day, had she? Had you?
No, that's not true. She was loading pretty consistently in the days prior. Maybe not perfectly, but she looked pretty comfortable, and I just wanted to make sure that morning.
But every day there was some problem with some form, shape, or manner.
No, I wouldn't say that. It's not unusual for a horse to show a little bit of discomfort, but she was pretty comfortable for the most part.
Are you Are you describing the discomfort as resistance to the starting gate?
No, I wouldn't go as far to say resistance. It looks more just like a little bit of hopping, or just a little bit of hopping.
So 2 days before the race, Southern Charm was resisting the starting gate.
I wouldn't say resisting. I would just say slightly uncomfortable.
Have you ever testified differently before?
No, sir.
Your Honor, if I could have a few minutes to confer with my co-counsel. Mr. Fonsetti, have you been deposed before?
Yes, I have.
Have you given testimony under oath?
Excuse me, counsel, for the record, could you please identify who you're speaking to?
Your Honor,
That's
additionally,
right.
the counsel for the plaintiff is going to point to a deposition. Can he allow us to point
Page
us
in
to
line.
page in line, please?
You got it?
I'm pointing to page 8 of Ms. Wright Deppel, line line 17.
Line 24 or line 17? Excuse me.
Line 17.
Okay.
If you want to approach the witness and show the witness the deposition.
I'm not showing Ms. Wright, page 8 of her Deppel, line 17. Can you take a quick
What
moment?
was the date of the deposition?
The date was 2021, but April 17th, 2021.
Was she under oath?
You were under oath, Ms. Wright,
Yes.
and there was a court reporter in the room, right?
Yes.
And an attorney was present, right?
Yes.
I'm not showing her page 8, line 17. Can you have a quick second to read it over?
Would you like me to read it out loud?
Read it to yourself, please.
Oh.
Objection, Your Honor.
Well, there's no question, we just asked her to read it over. Let me hear what he's got to add.
Are you ready, Ms. Wright? You testified earlier that he would stop walking. He would stop in on his way to the starting gates. That's resisting.
I guess you could say it's...
Objection, Your Honor. Improper
It's just
impeachment.
saying, it's just-
I'll just move on.
Thank you. You're gonna need, I have a copy of her deposition in the court file here if she needs to. Why don't you hold on to that in case you need to refer to that. But members of the jury, depositions are not in evidence, so this is just counsel asking questions about prior statements.
Ms. Wright, Southern Charm had never trained for racing before going to Colonial.
Yes.
He has never trained for racing.
Sorry, yes, he has never trained before
In
Colonial.
fact, Southern Charm only trained for a week before the race.
Yeah.
And at the beginning of the week, as you described, he was resisting.
Yeah, he was uncomfortable in the beginning of the week.
In the morning of the race, you described it as perfect.
That's correct.
But besides that, he was resisting throughout the beginning of the week.
I wouldn't say throughout the beginning. It was just uncomfortable in the beginning, and then it was progressively better, and then it was perfect.
Let's skip to the day in question. Before the race, it was Kenny's job to load Southern Charm into the starting gate.
Yes, I assigned him to Southern Charm.
But Southern Charm started resisting on that day.
He was uncomfortable loading into the gate.
digging his feet into the ground and not moving is uncomfortable.
Yes.
The Southern Charm, Kenny couldn't have moved Southern Charm into that starting gate that day,
Well, he did eventually.
but he had help of another person.
Objection, Your Honor.
Sustained.
Southern Charm dug his feet into the ground, is that correct?
I'm not completely sure. That's what I've heard.
But you watch every horse get loaded, correct?
I watch overall. I can't keep my eyes on all 5 horses at the same time.
All horses were loaded already, correct?
Yes, at this point, all the horses were loaded.
Besides Southern Charm.
Yes.
So what horses were you watching being loaded if there was only one horse left?
Well, whenever they were taking a while, that's when I directed my attention to Southern Charm. And I was at the starting lever.
So you saw Southern Charm not bulging.
Yes.
You saw another worker come to help.
Yes.
The other crew member linked arms with Kenny,
Yes.
just like you suggested.
Like we usually do.
And they attempted to push Southern Charm into the gates,
Yes.
but that still didn't work.
No, she didn't load until he slapped her on the face twice.
And you were there watching.
Yes.
You saw Kenny allegedly slap Southern Charm on the snout.
Yes, a few
And
times.
you classify that as abuse.
I would say so.
And a horse that gets hit, would that make the horse angry?
Who knows? It could. It could startle her.
It could make the horse angry.
Yeah.
And yet you still didn't remove Southern Charm off the list?
Well, at that point, she loaded right in, and I already had my hand on the starting lever. It happened so fast, and honestly, I was appalled, a little bit shocked, but she went in.
Exactly, with your hand on the lever, ready to start the race.
Yes, as I do every race day.
And after Kenny fell over the floor, went to the hospital, you ran that race.
Yeah, we didn't know what the extent of the injuries were, and it's not the first time someone's been hurt at the racetrack.
No further questions, Sean.
I'm sorry, lead the way.
Ms. Wright, we were talking a little bit about the morning of the race, when you were working with Southern Charm. What would have happened if Southern Charm didn't load perfectly over and over again?
I wouldn't have put her on the starting list.
Thank you. No further questions, Your Honor.
Ms. Wright, thank you very much for your presence. You may step down and I'll take care of that. Thank you. Anything further from the defense?
Your Honor, at this time, defense rests their case. May we have a 5-minute recess before closing argument?
Yes. Members of the jury, this would be a good time to take another and the last bathroom break because once the closing arguments start, we're going to go straight to it. All right. Please don't talk about the case while you're in the hallway or in the bathroom. And I'll see you back here in 5 minutes. Thank you, Madam. Counsel, you all got to keep track of your exhibits. My jurors are having to move them to leave. closing arguments to you. As I told you at the beginning of this trial, remember what the lawyers say is not evidence, and you cannot consider their statements to be evidence. And if at any time they say something that you disagree with based upon your notes, you may proceed.
Thank you. It's easy to gamble when the risk isn't yours, or when the price to be paid is somebody else's. Today you heard a story how all the shot callers sat comfortably as they let their employee, Kenny, take his The story didn't start the day Kenny died. It began when Southern Charm arrived at Colonial. Horses are inherently dangerous, as you heard throughout this whole trial. That's why they're trained. That's exactly why they're sent to places like Colonial, to be trained. But what did Colonial do? They rushed the training of Southern Charm. They started him off with Mr. Bowers as the head trainer, but within a few days, switched it over to Miss Wright. Why? Ask yourself that. Why? You heard that today. The training was going too slow, as Miss Wright testified. And you see, going too slow, it's not in the interest of the defendant. He had a business to run. He had money to make. And they further ignored the opinions of employees that had decades of experience. All because Southern Charm was their brand new toy. They couldn't wait to use him. Everybody knew Southern Charm had potential. He probably is one of the great, he's probably a great racehorse. If not, he could be the best at Colonial. Southern Charm had no ceiling. He had a potential. But where things took a left turn was when they started training him. Things took a left turn when they switched him, when they switched the trainer. And on that morning, when the defendant thought that Southern Charm was ready to race, the defendant, who hasn't physically worked with the horses in years, high school, wanted Southern Charm to race and instead of listening to the workers themselves, all he saw were dollar signs. But Southern Charm wasn't the easiest horse to train. Most horses aren't. Southern Charm, since the day he got there, showed some sort of resistance, whether it was not walking into the gate, digging his feet onto the floor. That's resistance. Not resistance is walking straight into the gate. It's that simple. And you heard the testimony of the inherent danger of horses working in tight, confined spaces. The people I know, they think horses are beautiful, but they also forget that horses are 1,000-pound creatures, 1,000-pound animals, fierce. A 1,000-pound fierce animals confined to a tight, small place like this, which they naturally resist. And that isn't something they're going to overcome quickly. That's something that takes time, and that's something that Colonial did not have. There was testimony today from Mr. Bowers that Southern Charm had been resisting all week. He testified that 6 out of 7 days, Southern Charm had resisted. That's 6 out of 7 days. I don't know the exact percentage, but I know 6 out of 7 days, it's a lot. But to the defendants, it was enough. That one time, that one morning, Southern Charm did not resist perfectly. That one morning when Kenny died. One time was enough to let Southern Charm race. One time was enough to let Kenny be put in a dangerous position. One time was enough to ignore all the things that could possibly go wrong. Things went very wrong. Y'all saw it. It cost Kenny his life. And throughout this trial, we learned how and why that decision came to be. In fact, it was pretty obvious that the defendant talked with Miss Wright on that morning. There was 4 horses, no Southern Charm. That's a short field. And I bet before you walked into this trial, you didn't know what a short field was. And I'll get back to that in just a second. But after the defendant talked to Miss Wright on that morning, there was 5 horses. Southern Charm was added. 4 horses, that's a short field. And throughout this whole trial, you learned all about it. You learned and you heard about it. And I bet you know now what it is. Before the conversation, there was 4 horses on that list. Short list is not in the interest of the defendant. They couldn't go on with that race where bettors are already placed. It would have been too much for them, apparently. It would have been too much to refund everybody on that day rather than take care of their employees, a 15-year employee like Kenny. And we don't know what exactly was said between the defendant and Ms. Wright on that morning, and that's fine. We don't need to know. We don't need to know exactly what they said. It's simple. There were 4 horses before that conversation. There was 5 horses after that conversation. There was no short list before that conversation. There was a short list before that conversation. There was no short list before the conversation. A short list is not good for business. Not a short list is good for business. Now let's talk a little bit about Colonial Casino and what they tried to argue today. They have suggested to you that Kenny was the reason for his own death. They told you that he wasn't wearing a helmet that day. That's true. We're not disagreeing with that. It's not in dispute. But they haven't shown you not a single piece of evidence that that helmet would have saved Kenny had he had it on that day. There's no evidence. I don't have it. You don't have it. The defendants don't have it. Look at that helmet and use your common sense. You heard testimony from Mr. Fonsetti himself. This doesn't cover your eyes. It definitely doesn't cover your ears, as you can see. And where did Kenny suffer injuries to? From his ear to his eye. And where was he on that starting gate? On the platoon, which means what? He was above the horse. So if the horse bucks unexpectedly, that means he was hit from under. There's no showing, and it doesn't matter whether he had a helmet on, because there's no evidence. That is a distraction used by the defendant. And this is a courtroom, and this is a court of law, and any verdict you return must be based on the evidence. And you saw the text message to Kenny and his wife, between Kenny and his wife. No one ever challenged Kenny's qualification throughout this trial. Why? Kenny loved horses. This is what he did. And ask yourself, as you saw the text message today, what were Kenny's thoughts on Southern Charm? So don't be distracted by things that take away from the real issue here. The real issue is that Southern Charm should not have been on that starting list on March 24th, 2018. That's the issue, and that's why they're negligent and caused Mr. Kenny's death. And as the plaintiff, we have that burden of proving by preponderance of the evidence that their negligence killed Kenny. And how did we do that today? Well, first and foremost, companies have a duty to provide a safe work environment and keep their employees safe. That's not in dispute today. Every company has that duty. We next shown you that the defendant had breached that duty by failing to keep Kenny safe on March 24th, 2018, by allowing Southern Charm on the starters list, leading to Kenny's death. And we've next shown you that it's not really in dispute that the horse being on the starters list is what caused his death when the horse bucked unexpectedly, knocking him over that gate, causing his death. That's it, y'all. It's not a complicated case, members of the jury. Unfortunately, it makes it sadder. And this is a story that you heard. It's a sad story, and it's a story that you hear over and over and over again. Profits over people, profits over safety. Thank you, Your Honor. Thank you, members of the jury.
Thank you, counsel. Defense, you may proceed. You are on the clock.
Sometimes simple choices have tragic consequences. And that's what this case is about. The racetrack, it's a dangerous place. These are 1,000-pound wild animals that are trained for one purpose: to run as fast as physically possible the moment that gate opens. They're so powerful that you can feel your seat shake as they sprint by. And they're so dangerous that an ambulance is already on site waiting. Because even in a perfect world, there's still risks. Because that's the nature of horse racing. And that's why we're here today. No matter how properly and well trained these horses are, no matter how friendly they are, no matter how experienced the people are, they're still wild animals. Because you can have all the rules in place, and you can have all the precautions in place, but someone can still get hurt. Or even worse, as we saw on March 24th, 2018, someone can tragically lose their life. Now folks, it's not lost on us that you may be feeling some sympathy for Mr. Carter. We feel sympathy. Kenny Carter was a member of the Colonial family. He was a loss for us too. And the plaintiff, well, she's someone that's lost her husband. Naturally, she's very upset. And you may be feeling some sympathy for Mrs. Carter as well. That's okay. That's all right. That's what makes you human. But as jurors in this case, you took an oath. An oath to follow the law and apply the law to the facts. That's your honor and your duty in this case. And it's not going to be easy. What we're asking you to do, it's not going to be easy. Because at the end of this, you're going to have to look the plaintiff in her eyes and tell her, no. I'm sorry, but no. The facts don't support a verdict in favor of the plaintiff. Now, putting our sympathy aside and applying the law to the facts, let's look at how the plaintiff was unable to carry the burden during his trial. And the only just verdict is a verdict for the defense. As we heard, Southern Charm was properly trained. Every horse is different. Some need more training, but some need less. And Southern Charm passed every single benchmark in order to be put on that starting list. And when Jamie Wright took the stand, the head starter for Colonial, the one with the final authority to put a horse on the starting list, well, she told us. She said on the day of the race, Southern Charm loaded perfectly over and over again. But we also learned throughout this trial that going into that starting gate is against a horse's nature. It's small, it's tight, it's confined. And so Colonial has some policies and procedures for that. We learned about the techniques assistant starters are supposed to use. But most importantly, we learned about the policy and procedure about wearing a helmet. That every single employee at Colonial has to wear a helmet when working with these horses. Especially the assistant starters. The assistant starters who are tasked with loading those horses into the starting gate. The most dangerous place on the entire racetrack. And these helmets, they're provided by Colonial to every employee. And the rules, they're provided to Colonial, to the employees by Colonial. Members of the jury, Colonial's asserted an affirmative defense. And what that means is it's our position that Mr. Carter's own choices and his own actions led to terrible consequences. On the day in question, we heard over and over again, Mr. Carter didn't wear his helmet. Perhaps it was too hot. Perhaps he forgot. Maybe he just got complacent. And we've all been there. We've all done something so long that you skip a step. It doesn't mean Mr. Carter's a bad guy. It doesn't mean he was deserving of what happened to him. But it is a fact that we have to consider in this case. He knew the rules. He didn't follow them. But on that day, that wasn't the only rule Mr. Carter didn't follow. We heard about his difficulties loading Southern Charm. And instead of using the techniques and methodologies that Colonial tells their assistant starters to do, Mr. Carter took it upon himself to do something different. He decided to slap Southern Charm, not once, but twice. That's against the rules. And Mr. Carter knows that's against the rules. This is just another example of Mr. Carter not following rules. Rules that are put in place for his safety. And that's what this case comes down to, folks, is two things. That Mr. Carter didn't wear his helmet when he knew the rules, and that this is inherently dangerous. No one knew that better than Mr. Carter. Even when his wife took the stand, the plaintiff in this case, she told us that he knew how dangerous it was. We heard over and over again about his experiences there, and how much he loved the racetrack, and how great he was as an assistant starter. But the one thing we'll never know is why he didn't wear his helmet that day. And sometimes, simple choices have tragic consequences. And that was a choice he made. This trial's about over. In a moment, the plaintiffs are going to have a chance to come back and talk to you. And after that, you're going to go back and deliberate. An honorable judge is going to give you a verdict form. It's going to ask you a few questions, but the most important question it's going to ask you, the question that's been central to this entire trial, was Colonial Casino's negligence the cause of Mr. Carter's death? No. We know that answer is no. Because we've heard all the testimony. We've seen all the evidence. And we know that the only verdict supported by the truth and supported by the law is a verdict finding Colonial not liable. Because someone did take a gamble with their life that day, and it was Mr. Carter when he unfortunately decided to not wear his helmet. Thank you.
Rebuttal? You have 5 minutes.
The defense is right. Simple choices have tragic consequences. It would have been simple not to run and see Southern Charm, especially after the whole week of terrible training that he went through. Especially after right before the starting gate, he dug his hooves into the ground. He wouldn't budge. It would have been simple to not run and see. It would have been simple to enforce the safety policies that they had in place. It would have been simple to train as Southern Charm as they should have, without rushing. But they never made any of those simple choices. Not once. Yeah, we understand our risks. All of us can agree that horses are inherently dangerous. But it's their job. They're their employer. They're the one that has to provide the safe work environment. They're the one that has to keep the workers safe. Throughout this testimony, throughout this trial, they have mentioned that they saw Kenny slap the horse twice. How that was abuse, how that was cruel. They saw that, and within their policies, they state, sorry, Your Honor, I thought they had left my.
It's ready.
Y'all saw the policies. They don't tolerate abuse, yet they still let Southern Charm onto the starting race. And if they saw Kenny slap the horse twice, as they say, which has not been proven, that means they saw Kenny with no helmet. And you heard today, whose job was that to enforce? Miss Wright. She was there, she was watching as she always does. She testified to that today. She watches every horse load into the gates. She saw Kenny with no helmet and made no decision, even though it was a simple one. And that simple failure led to the tragic consequences that we saw today. Throughout this trial, we noticed, and we have proven, that the defense had intended to make a killing of Southern Charm through racehorsing. And they did make a killing. Not the one that they expected, but the one they absolutely should have. And that decision led to Kenny's death. Thank you.
Thank you, Counsel. If you move forward. Thank you. All right, members of the jury, I'm going to instruct you now on the law that you must follow in this case. It is your duty as jurists to decide the issues and only those issues that I submit for your determination by your verdict. In reaching your verdict, you should consider and weigh the evidence, decide the disputed issues of fact, and apply the law on which I instruct you to the facts as you find them from the evidence. During the course of this trial, it has been my duty to rule on a number of questions of law, such as objections on admissibility of evidence, the form of questions, and other legal points. You should not draw any conclusions from those rulings, either as to the merits of the case or as to my views regarding any witness, party, or the case itself. It is the duty of the lawyer to make objections that the lawyer feels is proper. You should not be influenced by the fact that these objections were made, no matter how the court may have ruled on them. You must disregard any evidence which I have ordered stricken, and if I sustain any objection to any question, you must not speculate about the answer or what the answer might have been had I permitted the witness to answer. Any person who testifies, including a party, is a witness. You are the sole judges of whether the testimony should be believed. In making this decision, you may apply your own common sense and everyday experiences. In deciding whether a witness should be believed, you should carefully consider all of the testimony and the evidence, as well as whether the witness's testimony was affected by other factors. You should consider such factors as the witness' behavior on the stand and the way of the witness's testifying, the witness's opportunity to see or hear the things about which the testimony was given, the accuracy of the witness's memory, whether the witness had a motive not to tell the truth, whether the witness had an interest in the outcome of the case, whether the witness's testimony was consistent, whether the witness's testimony supported or contradicted other evidence, and whether and the extent to which the witness's testimony in the court differed from statements made by the witness at any previous occasion. You are the sole judges of whether a witness should be believed. You need not believe any witness, even though the testimony is uncontradicted. You may believe all, part, or some of the testimony of any witness. You must consider and decide this case fairly and impartially. All persons, including corporations, stand equal before the law and are entitled to the same treatment under the law. You should not be prejudiced for or against a person because of that person's race, color, gender, religion, political or social views, wealth, or poverty. You should not even consider such matters. The same is true as to sympathy for any party. In making your decision, you must consider the evidence in this case, that is, the testimony from the witnesses who took the stand, and physical evidence or exhibits admitted into evidence, and stipulations. That was anything that was read to the jury, and I instructed you about that. In evaluating the evidence, you should consider in light of your own experiences. You may draw any reasonable conclusion from the evidence that you believe to be justified by common sense or your own experiences. Objections by the lawyers are not evidence, and you should not give them any weight or consideration. You must not consider exhibits that I did not admit into evidence or testimony that I ordered to be stricken. You must disregard questions that I did not permit the witness to answer, and you must not speculate as to possible answers. If, after an answer was given, I ordered that the answer be stricken, you must disregard both the question and the answer. Opening statements and closing arguments of lawyers are not evidence. They are intended only to help you understand the evidence and to apply the law. Therefore, if your memory of the evidence differs from anything that the lawyers or I may say, you must rely on your own memory of the evidence. The party who asserts a claim or affirmative defense has the burden of proving it by what we call the preponderance of the evidence. In order to prove something by a preponderance of the evidence, a party must prove that it is more likely so than not so. In other words, a preponderance of the evidence means such evidence, when considered and compared to the evidence opposed to it, has more convincing force and produces in your minds a belief that it is more likely true than not true. In determining whether a party has met the burden of proof, you should consider the quality of all the evidence, regardless of who called the witness or introduced the exhibit, and regardless of the number of witnesses which one party or the other party may have produced. If you believe that the evidence is evenly balanced on an issue, then your finding on that issue must be against the party who has the burden of proving it. The issue for your determination in this matter is whether Colonial Casino and Racetrack LLC was negligent in failing to protect the decedent, Kenneth Carter Sr., and if so, whether such negligence was the proximate cause of Kenneth Carter's death. The term negligence, as used in these instructions, means the failure to use that degree of care that an ordinary, careful, and prudent person or business would use under the same or similar circumstances. The law does not say how a reasonably careful person or business would act under those circumstances. That is for you, as the fact finders, to decide. When I use the words ordinary care, I mean the care a reasonably careful person or company would use under the circumstances similar to those in the evidence or shown by the evidence. The law does not say how a reasonably careful person would act under those circumstances. That is for you to decide. Proximate cause is an act or failure to act which in the natural continuous sequence was a substantial factor in providing or producing the injury and without which it would not have occurred. Proximate cause occurs when the injury is the natural and foreseeable result of the act or failure to act. In order to establish negligence on the part of Colonial Casino and Racetrack LLC, the plaintiff had to prove that 1, the Colonial Casino and Racetrack LLC had a duty to provide a safe work environment by using ordinary care for the safety of its employees, including the decedent. 2, Colonial Casino and Racetrack LLC breached or failed their duty by doing something a reasonably careful person would not do, or failing to do something a reasonably careful person would do. 3, the Colonial Casino and Racetrack LLC acts or failures to act were substantial factors in producing the death of Kenneth Carter Sr., and without which the decedent's death would not have occurred. And 4, the plaintiffs received injury in fact. It is not your determination at this time the extent of to determine the injury. I'll start that over. It is not your determination at this time to determine the extent of the injury or damages to the plaintiffs. Your job is to determine whether there was in fact an injury. Colonial Casino and Racetrack LLC is a limited liability company. A company is liable for all damages proximately caused by the negligence of the company's employees while acting within the scope of that person's employment. In reaching your decision whether Jamie Wright or Frankie Fonsetti were acting within the scope of their employment, you must determine whether they were acting within the ordinary course of that business. In making that determination, you may consider any of the following: whether the act was expressly or impliedly directed by Colonial Casino, whether the act was in the ordinary course of business or naturally incident to the business of Colonial Casino, whether the act was performed, although mistakenly or ill-advisedly, with the intent to further Colonial Casino's interests, and whether the act was performed from some impulse or emotion that was the natural consequence of an attempt to do the business of Colonial Casino. Colonial Casino and Racetrack LLC has asserted 3 affirmative defenses. I will explain the elements of those 3 affirmative defenses in just a moment. The defense did not have to pursue all 3 of the affirmative defenses. To be successful, the defense had to establish each affirmative defense by a preponderance of the evidence. The first affirmative defense, comparative negligence. Colonial Casino and Racetrack LLC claims that the decedent's own negligence contributed to his harm. To succeed on this claim, Colonial Casino and Racetrack LLC had to prove both of the following. One, that the decedent was negligent. And two, that the decedent's negligence was a substantial factor in causing his harm. If Colonial Casino and Racetrack LLC prove the above, plaintiff's damages are reduced by your determination of the percentage of the decedent's responsibility. I will calculate the actual reductions, but you will need to provide the percentage of the negligence you attribute to the decedent's own conduct on the verdict form when asked. The second affirmative defense, assumption of the risk. Colonial Casino and Racetrack LLC claims that the defendant assumed the risk of the injuries sustained. To succeed on this claim, Colonial Casino and Racetrack LLC had to prove each of the following four elements. One, that the danger was not created by the defendant's negligence, but is normally incident to or inherent in the employment. Two, that the decedent voluntarily encountered the danger. Three, that the decedent was fully aware of, understood, and appreciated the danger. And four, that the danger was the cause of decedent's death. The third affirmative defense, proximate cause or superseding cause. Colonial Casino and Racetrack LLC claims a superseding or intervening act broke the chain of proximate causation between the defendant's negligence and the decedent's death. A superseding cause is a new independent cause that breaks the chain of proximate causation between the defendant's negligence and the injury. If you find that the defendant was negligent, but that the sole proximate cause of the decedent's death was a later independent intervening act that the defendant, in the exercise of ordinary care, could not reasonably have anticipated, then any negligence of the defendant is superseded, and such negligence was not a proximate cause of the death of Kenneth Carter Sr. If, however, you find that the defendant was negligent and that in the exercise of ordinary care, the defendant should reasonably have anticipated the defendant should have anticipated the later intervening or independent cause, then that cause does not supersede defendant's original negligence, and you may find that the defendant's negligence was a proximate cause of the decedent's death. In a few moments, my bailiff is going to take you into the jury room, and in that jury room, we have placed a verdict form. I have a copy of it here, and I'll just show it to you and describe to you what I'm expecting from you as jurors. I'm going to ask you to answer all of the questions that are on this verdict form, all right? Unless otherwise instructed. A yes answer must be based on a preponderance of the evidence, unless you are otherwise instructed. If you do not find a preponderance of the evidence supports a yes answer, then answer no. The term preponderance of the evidence means the greater weight and degree of credible evidence admitted in this case. Whenever a question requires an answer, other than yes or no, your answer must be based on the preponderance of the evidence unless you are otherwise instructed. And I will tell you that every question that the court is giving you has to be answered either yes or no. We'll give it a numerical percentage, and we'll go over that. At this point in the trial, you as jurors are deciding only if the defendant is liable. That's responsible. You will first return a verdict on that issue. If you find that the defendant is liable, then you'll hear additional argument at a different time, a different day, to determine the amount of damages that should be imposed in this case. Your verdict must be based on the evidence that has been received and the law on which I have instructed you. In reaching your verdict, you are not to be swayed from the performance of your duty by prejudice, sympathy, or any other sentiment for or against any party. When you retire into the jury room, the first thing you should do is select a foreperson. It can be either a male or a female. The foreperson will preside over your deliberations like the foreperson of a, I want to give you an example. A chairperson in a meeting. That's what the foreperson of a jury does. Okay? When you all have unanimously agreed, that means all of you have agreed on a verdict in this case, the foreperson will then fill in the answers, then sign and date the verdict form. And there's a line at the bottom that says, so say we all, this blank day, please put the date in, that's important. And then the foreperson, if you'll please sign your name, and if you write line and a dot, then I'm going to ask you to print your name under your signature so we can identify and know who the foreperson of this jury is. Please remember that I have given you all the law that is applicable to this case. There are no other laws that apply to this case. You must apply them. You must use them. Even if you don't like them, you still must adhere to the law. So at this time, counsel, are there any further instructions that I need to give to this jury other than the ones that have been agreed upon? Plaintiff?
No, Your Honor.
Camilo?
No, Your Honor.
Okay. All right, you are now free to go into the jury room to consider your verdict in this case. Thank you. Betty bought some butter, but she said this butter's bitter. If I put the bitter butter in my batter, it make my batter bitter. That's how it is reading preponderance of the evidence. Woo. All right, we're at recess, so I get to talk to the litigants.
All right.
But other than the gender, do the witnesses want to say anything to them?
To them.
Yeah, to the lawyers.
Good job, guys.
Okay.
Impressive.
It was impressive. You all have done better than some of the lawyers that have appeared before me. Trust me. It's like if I can just get to the part of reading that they show, oh, I forgot to give this to my bailiff. Okay. Madam Clerk, would you give this to the you can't because you were a witness. Oh, sorry. I just said
Not you, Mr. Fonseca.
Can you get those exhibits to the jury? I did promise it to them. Those are the exhibits.
We're still alive.
Okay, all right. Can I talk to them, or I have to wait till we're off the record?
Just give us a second.
Okay. All right, not a problem. You know I'm even on that.
Oh, I knew you weren't going to expect that. So that's why I opened that thing. I was like, I'm totally going to destroy this affirmative defense. If I do anything at all.
Y'all gotta get these genders right. Because you know what?
I know.
That's gonna happen in real life. One day you're gonna come in and you're gonna think that a certain witness because of their name, and you've not seen the person, and you're gonna say, okay, well, the name is Johnny May. You're gonna think that that's a woman because of May. Yeah. But then when a man comes in, you go say, hey, Miss Johnny May. And if you feel like the rock, they may knock you out. so you got to be careful on that. And that's part of going with the flow. Trials are fluid, and a lot of things happen that you, no matter how much you stipulate, how much you study, how much you go over testimony evidence, there's always going to be a ringer there. It's not going to be perfect. So,
okay, you can begin your comments.
Okay.
They'll be streamed. So.
Okay. All right, y'all want to sit down or stand up?
Oh, we're shocked.
I think he went to the restroom quickly. We'll be back in a second.
Okay. I'll let you go to the bathroom. You might want to go. I will give you a cut.
Oh my God, you got so lenient.
No,
you know let us go.
Well, you know, because y'all wanted to go at inopportune times when I was ready to get things underway. And I don't have a lot of time because the jury is on the time clock. They got 15 minutes. But I did, overall, I thought, they knew the case, but you all have tried this before, right?
Not this case.
Okay. All right, he's back. All right, let me, tell you some of my thoughts. For the most part, you did pretty good, but I find that when lawyers get nervous, they move without a purpose. They just start moving while they're thinking of the question. Don't move your body unless you've got something that's coming out your mouth. Okay, remember that. It's a coordination. Synchronize your mouth with your body movement when you're in courtroom work. Otherwise, some judges will tell you don't move away from the podium. I don't care where you go in the courtroom, it's less than, but have a purpose for moving. But by all means, please never approach a witness and never approach the judge without saying, may I? And some judges, they don't know, you pull out something and stop you. I didn't go into jurors taking their notes because it's not, I wanted to get that, I mean, too much proximate cause, but in cross-examination, and this was germane to both sides, never ask a how question. The question was, well, how did that happen? Or when you're crossing somebody, you're telling them what happened, and they're saying yes or no. How gives them wiggle room, and that happened a lot with Cameron Carter, and she was able to get a lot of stuff, her opinion in. She wasn't testifying as an expert. That was the ruling, that she could not give expert testimony, but she could definitely testify to what she saw and what she heard, and what her experience was. So, how are prosecutor and plaintiff questions? How, what, when, why? Those questions start off on a plaintiff or a prosecutor side, because you want the person to give an explanation. But when you're crossing them, you want them to agree with everything that you say, right? And that, but sometimes it's a little different. But you'll hear jury selection. Yes is not the answer. But when you're arguing and you're asking leading questions, you can say, the question was asked and the person could have said no. But they said yes, they agreed with this statement. They agreed, that's how you get around that. Also, Tyler, you were over here at the defense table, and you were looking at the jury, and you had your notes on the table. And so defense attorneys do what defense attorneys do. They looked at your notes, your questions. You don't want to give away the trade secrets, so you'll be careful where you put your notes in a courtroom. Know the lay of the land. Put them on a legal pad, okay? And take the legal pad up with you. And there's normally a podium, and leave it on the podium and walk. Get close. But I saw you go over a couple times, and then you got your little pad out, and you started writing. I said, okay.
I threw decoys in there as well.
Okay. See, judges have to look around and see everything. Also, when you were making a point about the helmet, and you kept saying for the record, well, if it's here and it's here, well, where is that? The record is not going to be reflective. Okay, is it between the forehead and the eyebrow, or the eyebrow and the cheekbone? You have to be real descriptive, because an appellate court reading that record, and I used to help young lawyers out by saying, well, where you pointing to, counsel? I just stopped that. I figured you're getting big bucks in civil cases, so you might want to do that. So. Be careful about the hearsay. You tried. I think it wasn't that you didn't know. It's just if they don't object, you get it in. Yeah.
Sorry, I mean, just as an evidentiary matter, we had hearsay exceptions ready to proffer for these statements. I don't know. I was just curious why.
Too late. No, I wanted seamless. I didn't want a lot of arguments, especially. even though the jury was supposed to, you know, disregard hearing us talk, I don't think the jury should hear, you know, these types of things. Work it out before trial. And I had all these procedural stipulations, everything you all agreed to and everything, and, you know, so let me get to your closings. Never make it personal. Mr. Camaro, you said, I don't have it, you don't have it, and the defendants don't have it. That's real dangerous. Because what if you had pre-trial gotten a motion in limine? Or you know, I made it a ruling on an objection to keep it out, and then it slips. Okay, I don't have it, you don't have it, and you said I more times than you should have. If you're going to say I in closing argument, you follow it up with submit. I submit to you. But when you make it personal, well, I don't know. You know, the law doesn't care what you know, what you do, unless you're testifying. So be real careful about that. But good pace, Tyler, you speak a little bit too fast.
Present time.
Well, I understand that, but you know what? I'd rather have it understood than to rush it out just to get it out. So, you know, but your pace was. And the closing, I'm not picking sides, but you have a great way with the jury. And you know, he was a good guy. He was a part of our family. Well, if he was a part of your family, why you in a courtroom? But you know what? You were selling ice to Eskimos or something. You know, it's like it didn't matter. You had that tenor about it. It was you know, he was a part of our family. That was so compelling. That hit home. And I think it may come back a defense verdict because you guys were kind of choppy. You know, make Kenneth Carter Sr. human. Okay? And one time he was Kenny and then Mr. Carter. Pick a team, pick a side. He was Kenny. Y'all consider it. Mr. Carter to them, or Kenny, but they can even call him Kenny. Make him likable. Now his wife, his spouse, wasn't like all that likable. But you know what? In a way, I'm glad that you didn't go after her. First of all, I'm not sure the conviction should have come in. Florida has a remoteness rule that if it's 10 years or more, the court doesn't have to allow you to use it as impeachment. So I didn't see anywhere in the materials where that was raised to keep it out. But that's why I let her go into it, so that they would know she's a convicted felon. And what's even worse, she steals. You can't believe nothing. This can't believe anything that this woman has to say, okay? Because she's a thief. She stole from the PTA, okay? The little children's fund, you know. That's why her own children don't even talk to her no more. Because, you know, she's a thief. She probably stole their Halloween candy or their Christmas gift, you know. So, but I'm kind of glad that you all didn't vilify her. But you could have worked her up a little bit more to make her likable. Because you don't know what the jury is thinking. They said, this woman steals from the PTA. Two of her children don't talk to her. We ain't giving her no money, okay? And then she kept saying, I lied. Okay, you lied then or you lying now, okay? So, yeah, as to what people were telling her. So that's why I sustained a lot of hearsay objections, because she was a loose cannon. And there was no telling where she was going to go. But this is a tough case, because, you know, you want to put the blame on Jamie for not enforcing the rules. But Jamie testified. That's not in my job description. Did y'all catch that? So everybody's putting the blame on her. That's not, you know, she absolved herself. That's not in my job description. So you horn in, and I like that, you know, you were trying to get out that every employee got a copy of the rules, and you should have made that really the centerpiece. He knew what the rules were. He just chose to disregard. And just because other people are doing it doesn't make it right, okay? So they put themselves at risk by not following the rules, okay? But, you know, they were arguing. Nobody told him he had to put it on, okay? So And then James said, that ain't my job. So that puts you all in a lurch. But all in all, this was a tough case. I had to read it twice and try to figure out, what the defenses were going to be and how it was going to be handled, especially with a lying woman. But you had a statement that wasn't read, lit. Are we lit?
The jockey.
Yeah. That could have helped you, okay? Because he said after some initial hesitation by the horse, we were fully mounted. Got fully mounted. And how come nobody put a picture in of the horse? I was like it. I like that. The horse, Southern Comfort. I mean, that's you have any questions you want to ask me while the jury is still deliberating?
Do you have any feedback on the openings that Alex and I did?
The openings were a little long, given the time that you had, but they were necessary. I thought both sides did very well by setting up the stage. I was following along. I have the statement of the case up here, but I wanted to hear from you all. So that was good. And I like the fact that you kept saying, and this is what the evidence is going to show. Okay? Because that's opening, what the evidence will show. But I don't have any problems with either side's openings. That's why I let you just go on. I didn't limit you. Because I think that's important. What's the lay of the land? What are we looking for here? Okay. I thought there could have been a little bit more humanization of Kenny. He loved horses. He worked for 30 years. Because the evidence would support that. You could have got that in my camera. Yeah.
To be perfectly honest, we had another Cameron Carter who was going to be our witness, and then she got ill today, so that Cameron Carter was kind of prepped in like 2 hours.
She was good.
And she's an attorney who obviously has other things to do.
She was good. I said, she learned this in a short period of time. She knew what parent mutuals were. Yeah, let me tell you about this. So, okay. So, but you know what? That happens in court. What happens if you had a corporate representative who was killed on the way to court, and you had to stick another one in there? So you got to anticipate this stuff. It's the same message, just different wrapping. Okay, so what else? Like I said, but look, I give you kudos. You've done better than some lawyers that have appeared before me. They were making a lot of money. So I think you all are ready. Third year?
Yes.
Or third year. Judge, I do have a few questions.
I'm listening.
Primarily, what county were you in? Broward, right?
Yeah.
And was it mostly civil or criminal?
I did mostly criminal.
Mostly criminal.
But I did 2 years in the civil division, where I tried 36 cases in 2 years. The lawyers were glad to see me go. I did more med-mal. I could resection the ballot. I did eminent domain. I did it all in the time. But I don't particularly like civil, because civil doesn't end. Because even with the judgment, you got remitter, you got all this aid and execution, it just doesn't die. Criminal, it ends eventually. So I like that. But I did a lot of civil as an assistant U.S. attorney. So 26D discovery, I was the queen of that. 11E, I knew it was exactly what that said. So, that's where the money comes out your pocket. Yes, sir. All right. All rise for the jury. Bill, did they behave?
Did.
All right, ladies and gentlemen, you all may be seated. The record will reflect the presence of the members of the jury, counsel for plaintiff, counsel for defendants. They're in. Our foreperson. Madam foreperson, have you all reached a verdict in this case?
Yes, Your Honor, we
If
have.
you'll pass it to my bailiff. Get up, man. All right, I'm going to have the clerk publish the verdict. this mic working for her? I want it loud and clear. Their mic is not loud.
We, the jury, return the...
And read it loud so they hear.
We, the jury, return the following verdict. 1. Was there negligence on the part of Colonial Casino and Racetrack LLC, which was the legal cause of death to the descendant
Kenneth Carter. Answer? Yes. 2. Was there negligence on the part of the descendant Kenneth Carter, which was legal cause of his death? Answer? Yes. 3. State the percentage of any negligence which was the legal cause of the death of Kenneth Carter that you charged to Colonial Casino Racetrack LLC, 80%. Kenneth Carter, 20%. So, say we all, this second day of August 2023, jury foreman, Sonia Rodriguez.
Does he decide which to have the jury polled? All right. All right, I'll enter this liability and I'll bring y'all back next month to determine the apportionment of damages. Members of the jury, as I always do, now that we have received the verdict, have a seat, Bill. Do you all want to say anything about this trial, the lawyers, the judge, anything, the clerk, the witnesses? Yes, sir.
Yeah, well, I wanted to say that it was very well explained, and when you guys did the opening statements, we kind of got a feel of what was going to happen through the trial. And for the defendant, well, even though we had someone that passed away and did something emotional, you guys kind of make that clear, but also represent your company as in why it was not your fault. So I really appreciate that.
Anybody else? Oh, come on. You're an old timer. You were here last year.
I mean, I think, first off, the wife, sorry for your loss, but that performance was amazing. It was, I believed it.
Where is she?
I don't know.
Can we have Cameron Carter come in and
Where's
talk
Mrs.
about
Carter's wife, please?
They want to talk about.
I just want to say we're so sorry for your loss.
Not a four-person.
We're gonna nominate for an Emmy.
Well, they were saying something about your performance.
Yeah, so I was saying that it had me in there. I feel like you did embezzle the money or whatever.
Oh, yeah.
It wasn't an accusation. No, 100%.
For anybody who's ever sat on a PTA, you get it.
But personally, I was in favor of the defense, I will say. I think you guys did a great job, referring to the loss and showing that empathy, but at the end of the day, you guys have a job to do, and Colonial, I personally believe, did complete their job. They did the bare minimum, whether it was right in our eyes or not. They did what they had to do based off their policy, to an extent. I felt like you guys also had a great argument showing that, they were complacent. They should have taken their, the Chaney, I don't know how she still had a job. She was reliability. The fact that she was there and did not do her responsibility of making sure that, the staff was following the protocol or the procedures, that definitely, was concerning, and you guys did a great job showing, that, at the end of the day, that they should have looked out for their company, and that was pretty much how that was going. I forgot my train of thought. But yeah, I think you guys did both a great job of explaining the argument on both sides of the case. So.
Did anybody not feel for the plaintiff at all?
I mean, I did. It's an unfortunate situation. It's tragic. But at the end of the day, it's a family business. Family business, I feel like, tend to be a little bit more lenient in certain ways. And he knew that. He was there for 15 years. He knew the helmet that they have obviously was the bare minimum again. And he chose his career. There's certain careers that we know that are risks, and you guys both shared that. Animals are unpredictable. He can't control that. The staff can't really control that either, so that's why I was you know, it's just tragic, but, you know, I felt the day was unavoidable. It
Better
could have been
helmets.
lucky, it could have been charm, or it could have been the other four.
They
So-
need better helmets.
Yeah.
Better design.
And fire Jamie.
And fire Jamie.
Bar her from the premises.
So you were back in the back saying, he had it coming.
Just out of curiosity, I do want to ask, maybe I missed it or it wasn't clear. How do we know that he slapped the horse?
We don't.
We don't.
I just wanted to
What is the testimony?
It's in the deposition testimony.
Okay, Jamie, not Jamie Brown.
And
where did the second,
Jamie Ryan
yes,
said
yes.
that's testimony. And remember, there's a part in the jury instruction, whether it's uncontroverted or not. If it's in the record, she said it. But did you all catch that Jamie said, that's not in my job description?
Yeah, that's what I said. But that's their fault for not putting a job that has safety under it. Like, they should have a job that is part of the job description.
In the record, she says, quote for quote, it's my responsibility.
Also, I got Frankie.
In the record.
Well, why didn't you cross-examine her on that?
We were running out of time.
We didn't know you were gonna give us 10 minutes guarantee.
Look, you never lose time. And the way you would do that is said, have you given a statement that's contrary to what you just told this jury today? Okay, get a little indignant, and then say, let me show you something. Counsel, page 8, line 17. Judge, can I approach? Okay, take a look at this. Read it to yourself and look up when you finish. Okay, you finished? Did you not say that, that this happened? Well, no, you said that under oath on this day, and that's it, right?
Yeah.
Yeah, I did. Okay, how long did that take me? Okay.
I feel like
You don't ever have, let me put it this way, you always have enough time to show that they lying. Okay?
I have a question.
What you gotta do is not as important as point out that they lied then, they lying now, they believe a lie. Period.
And also the past in terms of like, is it standard that if they do it good one time or one day, they can go in?
Exactly. I felt like I don't know how far into this you guys have to go with the prompt and everything, but were there any possible mention of you guys discussing their past incidents? What's their record? Have they had fatalities in the past? Like what?
She said it's not the first time somebody got hurt.
That was
To what
interesting.
extent?
That's called collateral or 404B, evidence of wrong. Normally that's very difficult to get in the trial because juries don't know how to separate the two. They're not on trial for the past, but the jury will let that in. So under the rules of evidence, the number, it's a lot of numbers, 404, box it, play it straight, whatever they do. I don't think that I would have let it in, even if they had tried, because not only is it evidence of other wrongs, crimes, or acts for which they're not on trial on, there's another provision of the evidence code, it's called 403. 403 says it's so prejudicial that its probativeness is outweighed because it's so prejudicial. If you had heard that they had 15 similar accidents in the past, y'all would have said, done deal, why we here? Judge, we don't need to go in the back, we ready.
That's true.
Yeah, right.
Actually, I think I still would have been defense because you knew it. Don't you Google where you're working at?
Would you
Oh, right.
You know what, there's really, sometimes it's an exception, but when you don't know who did something, for instance, you're trying to prove identity. If a person has a certain modus operandi, for instance, Ted Bundy, he would kill a woman and leave her bone. Okay, so they didn't know it was him, but they had these bodies, and then all of a sudden they get him and they tie it all together. Then that's when you let evidence of the other bad acts in to show not that they did something bad, but to prove identity, absence of mistake, things like that.
He knew he
but
was
I
good.
think in this case, I don't know if I would have let other trainers getting hurt, because then it becomes a trial in the middle of a trial.
Yeah.
Right. Could the plaintiff have asked the witness Jamie, to describe past incidents without,
Well, that would be evidence of otherwise. That's why I was very, very.
It's just her opinion, right? So
Yeah, and you know, unless it's a lay opinion or an expert opinion, those are two types of opinions that come in. Juries really don't need a lot of opinion testimony, okay? Because you can kind of figure it out yourselves. If you could figure out the preponderance of evidence and proximate cause and go back and then come back in 15 minutes with this, y'all frame this. This is the verdict. I think y'all are paying. Okay, the dollar was supposed to be the whole damages, so 80 cents goes to the plaintiff and 20 cents goes to No, but those are good questions. You know what, especially in criminal cases where I have allowed jurors to ask questions during the trial. I was trying to do jury innovation. And the first question that has always been asked, and I've tried murder cases now, has he done it before? So that's why evidence of other bad acts and things like that's why it didn't come in. But I know that's what y'all are thinking. Okay, so that's why it didn't come in. It's so prejudicial. Okay, and like I said, if you had found out, if Jamie had testified that 5 other assistant starters had been injured in the past, y'all would have said, Judge, could I just have the verdict for
Yeah, right.
So that was good. But then you think that the participants did
did
very well. So
No. Absolutely.
Let's hear for my clerk. And y'all gave me this bed.
All right, we have some hot food for everybody, so you guys stay seated for the moment, but we're gonna end our broadcast here.